There are some judgment charges.
For judgment, item 1.
Partly allowed.
Judgment, item number 2.
Seeking counsel here. I partly will tell you. I have Mr.
Sir. Item 1.
Item number 1 was there.
Yes.
I partly allowed it. Modifying sentence, upholding the conviction. I have modified the sentence to some extent, but upheld the conviction.
How many years will go?
2 years.
May I see the judgment?
Yes, you'll get it. I'll upload it. Huh? There are some minor corrections are there. I'll just do it up.
Tomorrow.
Yes.
Item 2.
Partly allowed.
Item 3.
Which partly?
Item 4.
It's allowed.
Item 5.
It's allowed.
Item 6.
Partly. Yes, sir.
Item number 58 of weekly is fine. This week I may be accommodate. My mother has undergone a.
It's all right. You need not mention. I will accommodate. No problem.
Lordship may mention that next week actually.
Yes, no problem. 58 location for the. Don't take it apart.
Out of list.
The last occasion I was not there. The Lordship pass over unless I present personally.
So
it will be.
for the presence, write down presence. Let counsel for the appellant. If there is judgment in view of the personal difficulty, he is the matter. Then I'll put it in the first week of January. Immediately first week. Then he has some personal problem. Okay.
But mentioning Pradhan 8 of appeal. Listed lost.
If it is falling in my assignment, it will come.
Lordship.
There's okay.
39 of 2018 Manus appeal, my lord. 39 of 2018, my lord. It's not getting any pension, my lord, due to pendency of this case, my lord.
Is it assigned to this court?
Previously, and not.
You are mentioning in wrong court.
Many times this court listed this.
I may be
ପ୍ରେସ୍ ମ୍ୟାଟରଟା ଅର୍ଜେନ୍ସି ଅଛି ଟ୍ରାଏଲ କୋର୍ଟ ଜଜମେଣ୍ଟ ପାଇଁ ରଖିଛନ୍ତି 18/12 କୁ
Which matter is this?
ଏଟା ଏନ୍ଆଇ ଆକ୍ଟର ଚେକ୍ ବାଉନ୍ସ କେସ୍
Item. International.
No, this is not in this court.
ସେ ବେଞ୍ଚରେ ଥିଲା
Previously, but now the assignment change.
ଅନରେବଲ ଜଷ୍ଟିସ ଏକେ ମହାପାତ୍ର
Show me that.
ଅର୍ଡରଟା
There is a direction, huh? Verification lagay. Okay.
ଅର୍ଜେନ୍ସି ଅଛି 18/12 କୁ
So this is criminal miscellaneous, na?
Next time also police single question sir.
No. Whenever next is today is the 18th, na? Put it as 18th. Okay.
I may be pardoned to question your lordship. Item 27 of the weekly list, your lordship. The file has been misplaced, so your lordship may allow me to take it with.
File is there.
No, my
Not
lord.
misplaced, it is there.
And Mr. Mishra is also not well. He has some teeth related problem, your lordship.
No, you tell other problem. Don't say file is
No, my lord.
misplaced.
File is also.
File is there. You get a pen drive and take the entire file.
My lord.
It's not missing. It's there. Get your pen drive and come first. So that next time you will not mention that file is missed. You
My
take the file, then I'll accommodate you.
Your
But
lordship.
take the file first.
Your lordship.
Okay? Okay.
Item.
27.
27.
Oblige, your lordship.
Yes, any mention?
My lord, the matter was listed this week's list, last week weekly list, my lord. And my lord, we had taken a short adjournment for this week, my lord, but inadvertently it has been posted to February. We checked out the order sheet, my lord. And there is a.
What is the offense?
My lord, offense of FR question, my lord, and 420 is involved, my lord.
Washing of the fire.
My lord, the urgency is
So
involved.
I'll make it to January.
My lord, A.
Because see, there are 2 working days only. I don't think it is possible. Put it on 23rd then. 23rd. Oh, then non-appear, nobody appears, what to do?
The issues, মানে আমি ভাবিলু কি সেটা next Tuesday হয়েছে দেখলা বেলকু সেটা সেইদিন Wednesday মানে Thursday.
Then what to do now? There is a judicial order. You have to ask for, move an application so that I'll prepone and hearing. Move a 1-page application
My lord.
so that I can prepone and hearing. Okay? Okay. Get ready with that day. I'll prepone and there and then I'll hear it. Okay. Yes. One.
Item 1.
Alive.
Yes.
Okay. Alive. It is, this is 2000 ready, yeah? Both the Sarala. Before place of that. Okay. List it on the weekly. Yes. Yes.
Item 2.
Yes, my lord. My lord, I am accommodated for next week, my lord, 23rd.
You want 23rd? Okay, on the request of
Yes, ma'am.
Mr. Patra, let counsel for the petitioner, lease the matter on 23rd. 23rd. Okay. Okay, 23rd.
Obliged.
Item
Yes.
3.
Yes, sir.
My lord. In this case, my lord, the present petitioner approached before this one earlier. My lord, sir, lordship have glanced the relevant portion of this order, page 39, lordship, and the impugned judgment. My lord, sir, passed the judgment in the
39.
My lord, page 39, lordship.
Okay.
Taking into consideration the case into entirety, I am the consider view that the petition should get at least one opportunity to lead his evidence in rebuttal. Therefore, it is open for the petition accused to obtain report from a private handwriting expert. Place it on record if so advised. If it is also open for the petition to lead any other evidence to prove his case on his defense. But that should not be at the cost of delaying the proceeding inordinately. And my lord, 12 parare, lordship have also confirmed the trial court shall afford petition at least one opportunity to examine the witness or place on record any scientific evidence.
Yes.
My lord, so far as scientific evidence is concerned, the present petitioner approached before the London in compliance of the order of the Senate court. My lord, I pray, my lord, let them, and the cost of the present petitioner, the record may be transferred to the private scientific agency, though so in compliance of the order.
That application you have to move there. Why should I do it?
My lord, they consider, that's why the private agency, my lord.
Have you moved the application before trial court?
My lord, I am submitting on compliance of the, also I am submitting, my lord.
Where is that application?
My lord, I've not.
Has it been rejected?
No, my lord, I am giving the initial.
I only say that
lord.
you wanted that your check should be handwriting expert should report should come. I say that privately you do it,
My lord.
and put it as your defense.
Though, my lord, it is, my lord, the, so far examination is concerned, my lord, the laboratory is concerned, my lord, laboratory is initially required, my lord. That's why, my lord, I pray, my lord, on the cost.
I understand your problem, but
My
have you moved application before trial court?
My lord, I'm submitting, my lord.
You submit and get it.
I mentioned, my lord, in the paragraph. Lord.
Once it is rejected, then on the basis of your apprehension, I'll
My
pass an order.
My lord. If lordship may.
You are apprehending that the trial court may not do, therefore I'll have to pass an order. What is this?
Orally.
I have passed a very exhaustive order.
My-
You
my-
move an application.
My lord.
If that application is rejected, you come so that I can address that.
My lord.
Move the application.
My lord.
I'll simply adjourn it to February.
My lord.
Okay?
My-
You move application. If that application is rejected, you tell me so that I can help you.
Liberty, my lord,
I will not say anything. I'll simply adjourn it.
my lord, the argument, final
Okay,
argument is.
persist to the order
I
dated.
pray, my lord,
but-
adjournment petition may be moved.
No, no, I will not delay at no cost of delay. This is what, which is the order, last order? No, pursuant to the judgment dated 13/2/2025, the petitioner has fairly admitted that he has not moved before the trial court by moving appropriate application. In view thereof, he seeks to withdraw the present petition to do needful before the trial court. If the liberty is disposed. Yes.
Item 4, my lord, kindly pass on. Next item.
Pass on, I'll put it on 19.
After lunch, my lord, Mr.
Nine.
Mahapatra is
19, 19.
requesting on.
19. Yes.
Item
19.
My lord, one pass on.
My lord, is adjourned.
After lunch, my lord.
Okay,
Possible.
pass for after lunch. Okay.
After lunch, my lord.
Yes.
Item 5.
5.
My lord, in judgment, my lord, in judgment paragraph 5 रे जो FIR law
Judgment, sir. Paragraph
paragraph
5.
paragraph 5 रे my lord जो FIR register ହେଇଥିଲା 5 month जो ଲେଖା ହେଇଛି ସେ 5 month ଜାଗାରେ 863 ଦିନ ହବ.
Okay. This is an application for the modification of judgment dated 19/8/2025. Land Council for the petitioner submit that in paragraph 5, the paragraph 5, it is mentioned that the FIR was delayed. Registration of FIR was delayed for about 5 months. In fact, it is
863
63 days. To that extent, he needs correction of the judgment dated 19/8/2025. Accordingly, in the para 5, necessary corrections will be carried out. Okay.
oblige my lord.
And after replacing the paragraph 5, fresh judgment will be uploaded by replacing the.
Item 6.
Item 6, my lord, is a content matter. The order is yet to be complied with. The government has already instructed the EIC. Your lordship will see the letter.
Requisites for issuance of notice not yet received.
Government has already issued the letter to the EIC to issue the order of appointment in favor of the petitioner within 3
Can
working.
you withdraw it?
No, my lord, EIC is sitting over the matter. EIC is also a contender here.
Who is the contemner?
All the opposite parties, EIC is.
But now the process has started.
Process started, but.
Don't deny them, they will keep it.
No, your lordship will keep it pending so that they can comply the order
They
of
have
law.
started now, they are doing.
No, they have, your lordship will see within 3 days. Already
See, I'll
issued.
tell you, the
Letter was issued
you
on
know the
10.
bureaucratic approach.
10, 12. my
Because
lord.
they
Once
will
the
say
con-
that since you have filed a contempt, we will not do.
No, once the contempt is, my lords, disposed of,
Service,
they will sit over the matter, my lords. That is why I pray, my lords, your lordship posted the matter to next week and let them file the
next week,
compliance.
least it in the second week of January. But this
Compliance.
pendency may create problem for you. Therefore,
No, it will not.
you can withdraw it with the liberty to file a fresh one if they don't do it. That's a better idea.
No,
I'll tell you why. What happens is the bureaucrat says that since you have filed it, let it be decided. So
no.
that may be a problem for you. It is your.
It's a compliance. It's nothing
It is-
to decide.
Yes, sir. All right. Second week.
Yeah. Problem.
Item 7.
May I please, your lordship? Your
This
lordship
is
was
bail matter, how it has come to me. Modification.
modification, my lord. Your lordship may have a glance to paragraph 8 of the order, clause number 4. Actually, I would a case of wife because 420 then in view this will not be released.
Similar type of entity.
हाँ से 420 498 420 ରହିଯାଇଛି ୱାଇଫ ଆପ୍ଲିକେସନ ଉପରେ କ'ଣ ଏଫଆଇଆର ଉପରେ ତେଣୁ ସେ କୋର୍ଟ ଆଉ ଆକ୍ସେପ୍ଟ କଲେନି ଆଉ ସେ ମୁଁ ଦେଇଛି ଡକୁମେଣ୍ଟଟା ଦେଇ ସେଇଟା କେସ୍ ନମ୍ବରଟା ଖାଲି ମେନସନ କରିଦିଅନ୍ତୁ ଯେ ଆପାର୍ଟ ଫ୍ରମ୍ ଦି କେସ୍
No, what was the case in fact?
420 ଟା ୱାଇଫ ଲଗେଇ ଦେଇଛି ତ ଇଏ ବି 420 କେସ୍ ଥିଲା
So you promised to give the job and taken money.
ଆଜ୍ଞା
The other case which is registered.
wife instituted under section 498 and charge sheet was submitted 498 under section 420.
Your,
Sim-
your client is a very celebrity. He's into all kind of problem. Huh? 420 also 490. Right. This is application for modification of the order dated 24/9/2025. The senior counsel Mr. Mahapatra submits that in view of the because of the condition number 4 inverted comma, that is i.e. He shall be released on bail subject to verification of similar type of engineering. The trial court has declined to release the petitioner on bail because at the instance of the wife of the petitioner, there is an FIR registered under section 498 A 498
and 420.
4 DPA. 4 DPA and 4 DPA. Hence, he
Along with the other offense.
and other which is arising out of a matrimonial discord. In view thereof, he seeks modification of the conditions imposed, condition as mentioned above. Regard being head to the reasons stated in the applications, the same is allowed. The condition number 4 imposed by this court while granting bail to the petitioner by the order dated 24/9/2025 stands withdrawn. With this modification, the application is allowed. Yes.
Before parting, may I say one thing? It is a humble request. Today I am hard pressed. If I will not available, the matter is the hearing list. If I will available, definitely I will. Otherwise, somebody will make a mention.
It's all right. It's always a pleasure hearing you.
Mention
Okay, no problem. Yes.
Item 8.
Sorry for the inconvenience, minor, there is a delay of 3 days, minor. Filing the liquidation.
Are you why you delay filing liquidation 3 days delay? The same may be accepted in the way appropriate. Yes, 9.
Item 9, Your Lordship, we have no instruction to appear. We have no instruction from the client, Your Lordship.
What?
No instruction from the client.
What no instruction? This is a criminal appeal. What no instruction? You have to argue?
My lord, we have no instruction from the client to appear.
Huh?
No contact with the
You may not have contact, but you are junior of
Mr. Lordship.
I am appointing you as amicus. You do it. Counsel, what is your name?
Ambarish Mishra.
Huh?
Ambarish Mishra.
Amrish Mishra, on behalf of Mr. H.S. Mishra, appearing for the appellant, submits that their office has no instruction in the present matter. Therefore, they don't want to conduct the present case. In view thereof, so and so is appointed as amicus curiae to assist the court. Take the pen drive and get ready. It will remain here only. Thursday, do it. Because 94 case, I will not wait. What is the offense, by the way?
Offense, my lord. 376, 359, 307. Read with section 3.
What is the sentence?
Sentence 7 year is maximum.
It's a big case. You have to get the pen drive and take it. Paper book is there. Just see. It's not there. It's there, I think. Big one. Then you take it. It is. Item 10. Yes.
Here is the 4 appellants, out of 4 partners are expired. Conviction for 304 part 2, I plus and 323 1 appellant.
What do you want? Somebody has to argue.
Last year was directed, if nobody has entered appearance, then.
Okay. ये जो amicus curiae वाला ना, तो एक दो मैं appoint करूँगा. हाँ, जितना. None appears for ये. I give pass a common order. We appoint amicus curiae.
In this case, perhaps Mr. Niranjan Linkar, last revision and last revision I had informed, and he has come to that.
Thereafter, nobody comes. Pass over once. I'll pass it over on all the matters. Then we'll see. Yes. Item 11. Yes.
That is also lack if nobody has entered appearance. Therefore, also please to direct if nobody has entered appearance, then matter is.
We will pass it over, huh? Pass it over. I'll appoint by evening, nobody comes, then amicus curiae will be appointed. Yes.
Item 12,
Yes, sir.
Wait, please, your lords.
Yes.
Here the appellants are two in number. Out of the appellants, appellant number 2 has breathed her last.
Died.
Died.
Dulari Pandey died.
Dulari Pandey died. My lord.
Ah.
My lord, appellant number 1 is the husband, and he has been convicted for the offence under section 306 only, not 498 nor 4 DPI, for 2.5 years. My lord.
They were charged for.
They were charged for the offences punishable under sections 498, 304B, and in the alternative section 306, reduced section 34 of the
Acquitted in all charges, 306 conviction.
only.
And sentenced to?
Sentenced to undergo RI for 2.5 years.
Yes, 2.5.
My lord.
Yes.
My lord, to substantiate the allegation, my lord, prosecution has examined around 16 witnesses.
No, but no. Para 37 says in the result, I sentence accused Dulari
My lord.
under section 306 to undergo RI for 3
3 years.
years. Under section 498A.
My lord, to Dulari 498 was there, but with regards to present appellant.
But surviving appellant, there is nothing.
No, nothing. My lord, out of 16 witnesses examined for prosecution, my lord, I was going through the materials. No witness, not a single witness has whispered anything against the present appellant.
Okay.
Lord, in trial court has taken note of some letters which has been exhibited as exhibit 10, 11, 12, 15, 17, 18 and 19, which was purported to have been written by the deceased to her family members, my lord. That PW 11, father of the deceased, Anita, besides making oral statements, he has proved the handwritten letter of Anita on the basis the same has been.
And in those letters, your name
Nothing is there. Nothing is there. Well, Lord, in trial court on an analysis of the evidence on record, discarded 304B is everything, and in paragraph 30 of the judgment, summed up his case, entire evidence.
Let us see para 30.
30, my lord. After discussing everything,
what is the content?
My lord, before
not the husband.
Before my lord, paragraph 30, my lord will see that from paragraph 26, he has discussed about the letters. The trial court has discussed about the letters, wherein all the allegations are against the mother-in-law and father-in-law. But father-in-law has been acquitted, and the other accused relation of the
Dulari's mother-in-law.
Mother-in-law. My lord, paragraph 30, court has reached at a conclusion. What is the conduct of the husband? Next question mark. The letter and the letters indicate that it is the mother-in-law who had been mainly subjecting the deceased to ill treatment and cruelty, constantly in the worst form. Necessarily, one would be inclined to ask whether the husband was not providing any protection against such ill treatment and cruelty, whether he had been a party to it tacitly. For an answer to this question, one may refer to Exhibit 11 and the last letter marked as Exhibit 17. It may be repeated that, as disclosed by the deceased in Exhibit 11,
I saw it is a moralistic conviction.
That has been dealt by Honorable Apex Court. I was going through it.
That is there. What do you say? It's a moralistic view. Husband, you are supposed to protect the wife. This is known to everyone. Mother-in-law, father-in-law meted
and he was not saying anything.
Daughter and all. And the trial court says that your silence, not protecting the wife, is the complicity in the crime. Is it permissible?
PW 4 and 5, the independent witnesses, never of the PW.
PW 4 and 5.
4 and 5, my lord.
But para 30, see the reasonings. Reasonings are. Anyway, independent witness, you show me so that
Yeah.
at least we can think of.
PW4, my lord.
PW4, huh?
Four.
I know the accused persons and the deceased Anita. Deceased was the wife of the accused Narendra. In the morning of 24/9/91, I heard some sound of quarreling amongst some female members in the residence of the deceased. At about 10 a.m. of the day, we noticed the deceased Anita came out of the quarters of the accused in crying condition and was going on the road.
Female members were Sasu,
We called her and
We called her and being asked, she told that her in-laws did not like her and were not allowing her to mix with others, and so she is going away. Then we advised her to remain in our house till arrival of her husband, but she did not agree.
See, yes, this is very important. Then we advise her to remain in our house till the arrival of the husband. That means husband was not there.
was absent.
The previous incident, what had happened, that time husband was not there.
Not
He come.
But she did not agree and wanted to go back to the residence of her husband. Then I accompanied by my friend Parvati Barik to Anita to the house of her in-laws. Seeing us, her mother-in-law challenged us.
Again, mother-in-law.
as to how- Yes. How could we dare to enter into her house? Anita told that she had called us. There we remained in their house with Anita for about 45 minutes. Some other female members of the locality also come there.
No, last time, only the mother-in-law of Anita
Yes.
and her husband's sister's son
Who would be aged
would
about
be aged around
8 to 10
8 to
years
10
were present in the
were
house.
present in the house.
That is,
Why are you reading?
Yes.
Then husband, nothing. Then
5 is also same.
And the 5, my lord.
you find out anything against husband. We are on husband. Dulari is no more.
No more.
Find out from the evidence. 16 witnesses are there. Find out anything.
Another PW9 is also another neighbor, my lord.
Read it if anything is there against husband.
I know
What
that
has actually
persons-
happened, my lord, I was going through the records that this petition, this present appellant was a metric, no, under metric, madam. And he joined in the place of his father as a helper in the Raukla steel plant. But it was given an impression to the deceased that he is an engineer. That is there in the record. And for which he was mentally depressed. She was mentally depressed. We do 9 whole style.
Narendra was there when this incident happened in the house. If you see PW5,
But pertaining to instigation, pertaining to
That's right.
torture,
It
it's not
it could have been 304B.
my lord.
It can be if he 304B in the house of the husband, this unnatural death has taken place, whatever.
But 498 is the basic ingredients which should have been.
For 304B, that is not there.
Now, it is also required for 113A because 113A and 113B are two presumptions.
That is relatable to 498A.
No matter. Let me see. Paragraph 9. She would have been mother-in-law would have been convicted if 498.
No, for 113A.
Also, it's required. Well, let me see explanation. For the purpose of this section, cruelty shall have the same meaning as section 498A of the Indian Penal Code.
But that is not simplicity cruelty. Cruelty, demand of dowry.
Yes. So section 4 is also not there.
Because he has been acquitted for this.
He has been acquitted.
Then 313A cannot be
113A,
invoked.
yes.
113.
Yes, 113A if
cannot be invoked because this accused has been acquitted for 498 and 4. So that presumption you can't use. And
And-
you need independent evidence.
Yes.
Under 107.
Well, that
What
has
is
been-
there?
That has been clarified in 2023, volume 15, SCC 544.
Independent evidence.
Independent.
107.
306 read with 107. What is that? Wording?
Because you could have employed 113A, but for the acquittal under 498A and 4 of DP Act, 113A is not available to you. Then if 113A goes, then for bringing 306, the only option is 107 abatement. Where is the evidence for 107 abatement? Did you follow what I am trying to tell?
Yes, ma'am.
107 abatements, sue me from the evidence. He was present in the house and all these things, all right. But where is the abatement? And that abatement is 107 abatement. Which witness you want me to read? You tell me. Have you prepared or not?
Yes, ma'am.
Shall I take it at 12 o'clock?
Yes, sir.
Read it because 16 witnesses are there. It is a case of acquittal. It will go on your head. Clear cut case of acquittal. Because para 30 I read it. Para 30 is a moralistic statement. It can't be ground. The husband is pissed up between the mother and the wife. What to do?
Mother-in-law and father-in-law.
Generally, mother tortures the wife, and if he supports the mother, he is in trouble. He supports the wife, he is in trouble. Therefore, he chooses to remain silent. Is that a crime? And eventually something happens.
And that too, my lord, he being unqualified, he has taken up the job of his father as because his father has voluntary retirement from the place of helper. And other side, he was supporting his wife, but wife was not satisfied with him because she was told before her marriage that he is an engineer. But in fact, he was a helper. That he has stated so in that it.
All this thing is a cumulative effect, you know.
Cumulative
and
effect. Otherwise,
morally, the wife might be completely down. That dissatisfied marriage, and she might have done it. But there should be an abatement, straightforward abatement. Dulari is convicted for 304B, 306 and 498A and all, rightly. She has died now. That's a gone story. Then 12 o'clock I'll take it. You show me 107 amendment. Because 113A is not available to you because he has already been acquitted and 498A and section 4.
And
Okay?
4 DPIT.
Okay. 12 o'clock. Let it be 12:30.
Right.
At least he will be doing his other work. Okay. His judgment will occur Saturday. And you see the judgment also, which is citing.
Item 13. Item 10. Password.
बाबाकडे copy नाही.
Password.
Also, you sought for password.
Well, I was not there. That is
No, it's all. 10, huh?
It
Item 10?
10, my lord.
No, it is.
I pray for 23rd.
2014 Supreme.
I have collected all the documents. In fact, the file was not with me. I collected it from the office.
For you, it takes some seconds to read it. Why 23rd? I'll put it on 19th. Huh? 90, because these are 94 matters. I don't know. No, Thursday.
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 Thursday I can.
But Thursday, though. It will remain in the list only.
Yes, ma'am.
Thursday, I'll take
I know
it.
it is
Okay,
not
very
two
good.
days.
You have all the files and then you tell your junior to take from here.
Yes, ma'am. I will.
Send your junior. So anything missing, you can take it from.
Yes.
And undergone period also, let your junior find out. File records are here. Send
Yes,
your
madam.
junior in between lunchtime or something.
Yes, yes,
You
I
can see. Okay. Yes.
13.
13. Next week.
Why next week?
13 minute conviction is 304 part 1 and sentence is 5 years. Here question is valid informant has turned hostile, but one witness PW5 valid has stated that deceased after the assault he was in his house. On the next day morning I had gone to his house and he disclosed before me 3 names. Out of 3 names, my lord, they were seated and 3 names. One has been acquitted and 2 persons have been convicted for the offense under 304 part 1.
5 years sentence.
5 years. Peculiarity of the case is doctor has said if proper treatment would have been given, he would have survived. Because it seems the deceased while this occurrence has taken place, he was heavily drunk. Okay. Because of the next day morning, when PW had gone to his house, he found by the time I had gone,
Who are the eyewitnesses?
well, everybody has turned hostile except PW5.
PW5. Let us see PW5 one.
On the following morning of the occurrence night, that is page 56.
Yes.
I had been to the house of Sibo Sankar, deceased. I saw Sibo Sankar with injuries on his person. Sibo Sankar told that accused Bisse Kahara, Pinake Kahara and Champe Kahara assaulted him on the previous night.
All the 3 are
yes, they were placed
are
convicted. Conviction
Bisse and
is
Champo.
Conviction is with regards to 2. One has been acquitted.
Pinaka.
Melod.
Pinaka.
Champe or Bisse convicted. Pinaka Karnar has been acquitted.
This is his A1 and A2. Okay. Yes. Police see the sample at so.
He has said that in cross-examination, on the next day morning of occurrence, Sibo Kahara told me that he had been assaulted by the accused persons. But then it was 7 a.m. Sibo Kahara told in feeble voice, Sibo Kahara was in semi-conscious stage. On my query to Sibo Kahara disclosed in feeble voice. I put my signature in Exhibit 6. It is at Solandrapada police outpost. By the time Sibo Kahara was talking to me, Sibo Kahara had consumed liquor. I was alone present when blood stained earth and sample earth were seized by the police. It is not a fact that I am deposing falsehood. By the time Simakara told me, wife of PW1 was also present besides her husband.
Simakar is the deceased.
Simakar is the deceased, and wife is PW1. She has torn hostile, my lord.
Who is the doctor?
My lord, 3 doctors are there, my lord. My lord may see. One doctor, the 2 doctors and 1 pharmacist. My let me see 64, page 64. I was assistant surgeon, district headquarter hospital, Fulwani. Again says I am working as district headquarter hospital, Fulwani, since 1988 and continuing as such till now, but placed under suspension, so and so. He says, doctor, deceased was produced before me, but though it's a medical legal case, I have not examined the dying declaration. Sorry, I have not taken his dying declaration. And a query was made by the police. I have given my reply in the query, to the query. The cross-examination he has stated.
Not recorded the dying declaration of Simakaro, knowing it to be a medical case.
Death is after three days, valid, 3-4 days.
His statement is not recorded, 161 statement.
Yes, that has been recorded as exhibit and exhibited as exhibit 21 as per the IO, but
that could be treated as a dying declaration.
Yes.
Under 32.
My lord. But the doctor says, PW11 says,
contusion aberrations and contusion aberrations also fracture.
Had that period after the assault, he was not taken care of. He lied in his house as it is. And my lord.
Well, then what is the evidence except PW5?
Nothing.
He says PW5.
And doctor says, PW11 says.
Who has assaulted him? Who has seen?
Yes.
Who has seen it? See, PW5 says, Shivak or the deceased disclosed him that these people, 3 of them has assaulted him. And at the same time, he said that he was completely drunk. His voice was not audible properly.
Reading and praying manner, I am not reading. So
2 o'clock? Both the matter 2 o'clock then. 2 o'clock, both the matter. Let him read. 2 o'clock. 2 o'clock. I'll fix this 2 matter at 2 o'clock so that I'll take small matters. Any small matter, anybody is ready, come. Small matters. Huh?
Item 17. Very small.
70?
17.
17.
17.
17. Small matter means the sentence is small or matter is small?
Matter is small. It hardly take 20 minutes for my lord to appreciate my. Lordship, item number 22. Lordship, 6 months of conviction. A CST matter, Lordship. The investigation was not conducted by the DSP and delay in lodging of FIR only ground.
Which year?
Lordship,
FIR.
1994.
94.
22.
95.
Matter of the year 1994.
Incident 95.
94.
Then the rule came into force in the 95.
95.
Then why DCP?
Post 95, it was.
Post 95, by that time, charge sheet was already filed.
Lordship, as per section 17, as per the old Act 89. Lordship, a district magistrate or a subdivisional magistrate or any other executive magistrate or any police officer not below the rank of deputy.
So where are you reading? 7?
17, Lordship. Section 17 of the old Act.
Old Act, show me. But the rule 7 came March 1990.
95. But it was prior to that. The incident took place on 1/2/1994.
Where you are reading?
17, Lordship, section 17.
This is something different.
Lordship, and another point is that delayed
That
lodge.
point, see, this is first of all, it is the subjective satisfaction they may invoke, and this is a preventive action.
Yes, sir, Lordship. Lordship,
Where
and
does it
another-
say that the investigation has to be done by?
Lordship, and
the-
another judgment is there.
That might be at post 95.
Judgment.
The
of
FIR
post-
are if the FIR is registered post 95, that is 31st March of 1995, if I am not mistaken. On that day, the notification was issued under Section 7. That day onwards, if the investigation is done below officer below the rank of DSP, this
Yes,
is
sir.
not permissible. The entire investigation is initiated. Prior to that, there was none. And 17, you are reading, this is a preventive action.
Preventive action.
Preventive action that will not help you. That will not. Then it will take time.
Yes,
You have
sir.
to wait. Yes.
Lordship, may fix it on Thursday, Lordship. I will file a written notes. along-
Thursday. Come with a written note.
Yes, sir.
Finish it up. Yes.
Oh, bless.
17, what wanted to say?
But 15 also TCR.
Okay, the TCR.
TCR already confirmed, not received.
TCR 15 to TCR हो गया. Yes. 17.
17.
Yes, sir.
Conviction under section 20B, 1 NDPS Act 1995. And
That is place for, I'll reply. So I don't know what conditions they're taking, so I have to get prepared, so let them get the maximum. I'll reply.
Then I'll take it 12:30.
Say what, how they're taking, so that I can get prepared.
Let him argue at 12:30. You argue. Okay. Yes. What are the prime point you tell me?
my lord. Here, my lord, the occurrence took place in a well, NDPS, the contraband was detected in a running train, which was running from Koraput to down Kesinga and that station. At Kesinga station, the informant who was the constable of the railway police, GRP, he was on duty and he detected these two appellants. Out of these two, appellant number 2 has expired, man.
Okay.
Yes, ma'am. And he detected 3 attaches and 2 airbags. He came there smelling ganja. He perceived the smell of ganja and came to this compartment. First class compartment. He said the only compartment first class was available in the train, only one compartment first class. And there, my lord, he asked them, what was that? And he said that they admitted that it is their bag and the bag contains ganja. Admission. After that, there were other constables also on the train. They were while the train was running, they were not intimated. TT was not intimated. That these are all the points as far as detection is concerned. After that, they onboarded the train at Titlagarh.
Titlagarh.
And then it is said that they were carried to the police station. There, the OIC, he did all the search seizure and arrested these persons. Here, my lord.
Yes.
The occurrence, they said that it took place on 14/10/1994. And
but you tell me one thing, the facts sounds some similarity. Have you ever gone to Supreme Court for bail?
My lord, no, my lord.
I think I handle this kind of facts.
Case back of 1995, when I was not there in office at that time. I came up later on. 1995, I don't think, my lord, they were of that position to go to the Supreme Court. They were not. Check it up.
What's the period undergone, by the way?
My lord, period undergone.
But it's not very old. Recently, I think I have.
Lordship, then I will check out the period undergone.
Check out period undergone and see whether they have gone to Supreme Court for bail at any point in time. I think I have handled this
Then-
kind of facts. I remember because in the either in Kantavanji or Titlagarh they were apprehended. The police came, apprehended something of that sort.
My lord, they were not up. These two persons were in the train.
I know in the train it was informed, and these people went to the platform and apprehended them.
No, my lord. They were carried to the police station. From platform, they were carried to GRPS. And there all the seizure and all done. And the spot was not, the spot map could not be made because the train had already left the station. And it is not probably not.
And everything, seizure and everything is done in the police station.
In police station. And the case and learned trial court and all these metal objects and they were all seized. And more interesting thing is that, my lord, this samples were sent about a month thereafter. It was sent
After a month,
One month.
it was kept in the Malkana.
Malkana. 1 month thereafter. And the independent witness have not supported the case.
Oh, that's
The more, my lord, one of the weighing witness, he says that I do not know what the material was that I weighed.
3 kilo, huh? 3 kilo.
My lord. My lord is not 3 kilo.
That's
31,
it.
31.
Written note of submission I give here.
31 kgs.
You just
Yeah. Is there any statutory exemption?
that's
if
what
at
he
all-
says, that everything is done in the police station.
And if at
Picked up
all-
from the railway station and taken them to the
Yes.
police station, and everything is done there.
That is the running that has to be full.
It's not running train in the platform. They were picked up.
They were, yeah. When they were boarded in the train, and since it is from the Koraput to Bhubaneswar, there's only one train. So they could not have booked it there. So I'll satisfy to that one.
That apart, my lord, the admission part, that they admitted that these are ganjas and these are my bags. That part is not fortified by any judicial recording by itself or any admission before it. That is the.
Now you admitted that you are holding that 31 kg.
They say, the detecting witness, that constable, he said they admitted that these bags were containing ganja and these bags belongs to us. These are not fortified by any judicial recordings.
Just check it up. Huh? 12 o'clock? 12:30 or
2 o'clock after.
Day after?
Thursday, my lord.
Thursday.
Then in an hour.
12:30?
Yes, my lord.
He'll prepare.
Yes, my lord.
2 o'clock, that two matters have kept, na? That will not, yes.
There is statutory deduction between period. So I just have to reply regarding the detection and the constitution and regarding the delayed supply. So
2 o'clock. 2 o'clock. Make it 2:30.
Yes.
So that
We'll wait.
half an hour will take. Any small matters? Yes, yes, Mr. Mishra. Small matter.
33 minor.
Small one.
Yes. Only 490 day.
30?
33 minor.
Yes.
She will do, man.
Yes. She will argue and you will assist. Presence of both.
Lordship, appellant number 1 is the husband of the deceased. 2 is the father-in-law and 3 is the mother-in-law of the deceased. So father-in-law is dead and mother-in-law is currently.
How many accused are there?
Three.
Three applicants.
Meantime, appeal number 2 has already expired. Only remain appeal number 1 and 3 is concerned, appeal will be concerned.
Who is one? Husband.
Husband.
And who is 3?
A mother-in-law.
Mother-in-law. Okay.
Lordship, mother-in-law is currently 80 years old.
Yes.
They were charged under 306 and 498A, convicted for 498A, imprisonment for 1 year. The deceased and the appellant number 1 were married in 1993. She committed suicide in 23/4/1996, almost after 3 years of her marriage. Lordship, there is an inordinate delay in lodging the FIR. It's 5 months.
Delay?
5 months delay. But
5 months.
5 months.
How 5 months?
Ma'am, first an UB case was registered
Thereafter.
on behalf of the appellant number 3. Sorry, appellant number 2. My father. Thereafter, after 5 months after, on the instigation of a journalist, PW7, that FIR was registered.
Yes. Yes.
Lordship, the PW1 is the adoptive mother of the deceased. Lordship, there are a lot of contradictions in her statements also. She said that the deceased twice came back to her home after 1 year of marriage. For 1 year of marriage, they were all in a good relationship. So after she came back, they took no steps. They did not inform the village panchayat, nor they informed any important family members or members of the village. Even she stated before the death of the deceased on 22nd April, she went to her house, the house of the deceased. There she saw the violence marks, the appellants, they tortured her. But in the postmortem report by PW4 and 3, it is stated that there is no marks of violence in her body. It's only ligature mark due to the hanging.
Then how the trial court acquit them for offense at
Acquitted from 306.
306. Only convicted at
498A.
Because there is no abatement.
There is no 40P Act.
40P Act is also. Yes.
For Lordship, appellant number 3, her mother-in-law, in the 313 statement, she has clearly stated that they were living separately from their son. And which was also confirmed by PW1 in her deposition, that the deceased and her husband stayed separately from the in-laws.
PW5, madam. The IO in the UB case.
PW5. Is IO.
The IO in the UD case.
UD case, which was registered by the appellant number 2, the father-in-law of the deceased.
Father-in-law.
He has stated no other marks of violence is found, madam. And on the date of inquest, the 2 witnesses, that is the father of the deceased as well as the adoptive father, didn't allege anything regarding torture proceeding, the suicide or demand of dowry. There was nothing. Only the journalist interpreted in the matter.
Who is the journalist? PW7.
PW7, madam.
Let us see PW7. Read, madam. PW7. What does he say?
Still place from the beginning. I know the informant Purushottam Malik.
32, page 32.
Yes, I am there.
I know the accused person's Premlata, daughter of Purushottam Malik, accused Naran 5 years ago. Before marriage, Purushottam told me that he was giving his daughter in marriage with Naran and was giving all the customary gifts such as clothes, utensils, but out of dowry demand, he was giving an Atlas cycle and a Santosh radio set and was not giving the gold chain and gold ring. 2 years after marriage, once Purushottam told me that his daughter Premlata had come back home being ill-treated by her father-in-law, mother-in-law and husband on demand of the gold chain and ring. I advised him to fulfill the demand and he had promised the same. About 1 year thereafter, on 24/4/96, Purushottam again told me that his daughter had committed suicide. He further told me that he made an FIR, but the officers of Balichandrapur PS, namely Ghosh Babu and one Adhikari Babu, refused to accept the FIR and had registered a UD case. As Purushottam made allegations against officer IC of Balachandrapur PS and requested me to write to the higher authorities of police, and at his instance, I prepared some letters which were sent to SP Jajpur, DIG of Police Cuttack, DIG HRPC Cuttack. The copies of the papers are with me and I'm producing the same today. Lordship, neither of these documents are in the exhibit. I had
Not these letters and anything is it.
nothing. I had also
Also with regard to the demand of a gold ring and gold, that was neither in the FR nor in the any 161 statement.
I had also prepared a written report at the instance of Purushottam Malik, which was lodged at the police station. The document was scribed by me at the instance of the informant. I read over and explained the contents thereof to the informant, who, having found the same to be correct, gave his LTI Exhibit 4 is the written report scribed by me. Lordship, in the FIR, there is no exhibit certificate, scribe certificate. I was examined by the police. I was examined on the day following the death. It is not a fact that I did not state before the police that Purushottam told me that he was giving an Atlas cycle and Santosh radio as per the dowry demand and was not giving the gold chain and ring. I gave correspondence number 40. I have correspondence number 48 of Delhi Prajatantra. Till 2 years after marriage of Premlata, I had no information regarding any torture on her on dowry demand. On 24/4/96 in the afternoon at about 4:30 p.m. on my way back, Purushottam told me about his daughter's death. A village Mustakiri and Kolangiri are 1 kilometer away. On that date, I did not write any FIR as Purushottam did not tell me to do so. The FIR was scribed on 7/9/96 on the table of the officer IC Balichandrapur at the instance of Purushottam. There is no endorsement on the written report that it was scribed at the instance of Purushottam Malik and that the contents thereof were read and explained to him.
Where is Purushottam? 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 PW?
9.
Read PW9. Whether he told that he has spoken to PW7. Has he said that?
Yes, yes, yes. Paragraph 4. A journalist of my village wrote the letters to my instructions and took my LTI on those papers after explaining the content.
SPDA, these things are there corroborating.
Lordship,
It's corroborating. The journalist has written the letter to DIG and all because the Ghosh Babu and that Panda Babu, whoever it is,
but
they
there
did
is
not register the FIR.
But the
Rather,
police
they
is
registered UD case.
Police is saying nothing about this letter, man. Though he is, I have gone to the police station and lost the FIR. The police said he has already an UD case there and there is no need of second FIR. That is nothing in the scribed paper is there, madam. Not that Ghosh Babu has been examined.
That's not necessary.
Lordship, there is a contradiction in paragraph 4.
That what was the demand of dowry? This is cycle,
Gold
cycle or cycle and radio
chain.
or gold chain?
Gold
Cycle
ring and
radio.
chain.
Cycle radio is there and
Already given, or towards gold ring and chain is for demand.
there is no demand neither in the FIR nor in the 161 madam.
The FIR is also. Where does the father says demand of gold chain?
Radio say.
These are the developments, madam.
Nowhere they have previously mentioned to the police that there was any demand. Even during the inquest report, they did not say about the dowry demand or torture.
And that Purushottam is a witness to that inquest. And that PW5 is saying nothing. He is no. On the date of inquest, the said two witnesses, that is Purushottam and his adopted father.
Gold
didn't-
chain, gold ring.
PW5, madam.
PW5.
Yes, madam.
5.
To inquire the UD case, you know. Yes.
In paragraph 2,
Cross examination.
I want to.
I cannot say
Yes.
on whose information the UD case.
The case was initiated.
I
Did not prepare any spot map during inquiry of the UD case. I examined some witnesses but did not make any seizure. I examined the witness who have been cited witnesses to the inquest report. Witness Purushottam Malik and Baju Malik are witnesses to the inquest, and I
Purushottam Malik is the father.
examined them. The two witnesses are related to the deceased as father and adoptive father. On the date of inquest, the said two witnesses did not allege anything regarding torture preceding the suicide of Premlata on demand of dowry. I made over the UD case to Officer IC on 13/6/97.
Now, this is very important. While recording UD case, the same witnesses have not said anything regarding torture and anything other sort. That is the
But that.
IO of the UD cases.
But PW 5 not stated so, but evidence of PW 169, though is a related witness,
They
that
are
is corroborated by the independent witness regarding the dowry lordship and demand.
Gold chain
Yes.
and
So far here is a case.
gold ring and chain.
Yes, 498 TA lordship. So for 498 is concerned, three ingredients to be satisfied. Whether there is a valid marriage. or
I know
subject
they,
to
I
clarity
see
of-
that's the reason you have been acquitted for 304B and all.
Exactly, lordship. So
But demand of the gold ring and chain
This
is
was
consistent by
my lord, this
PW
witness so far.
This was
7,
neither
9,
in
1, 2, 3.
Lordship, I may take to PW 9, the informant, the father, adoptive father, paragraph 7.
7.
Yes, Your Lordship.
Okay.
From the downward side, 1, 2, 3, fourth sentence. They
Yes.
cannot say if Prema gave birth to one child or two child. Lordship, he lacks the basic knowledge about the deceased. Like
Yes.
she had one child or two child.
ବାହାଘର ବି କେତେ ବର୍ଷ that is doubt. Because
Lordship, I may
outside-
please.
minor.
How does it make difference whether at the time of marriage dowry was given or not? That
Because
Lord-
the period of
lack-
marriage nothing to do because the 304 is not there.
He lacks, Lordship, he lacks basic.
how will you discredit the evidence of PW
Yes,
1, 2, 3, 7 and
Lordship, 7 is an informant and the adoptive father. Lordship, he lacks basic knowledge about the deceased. Like she had one child or two child.
Yes.
I may place, Lordship. I cannot say if Prema gave birth to one child or two
PW
children.
9.
PW 9, paragraph 7. The
It's a-
child now living is aged about 4 to 5 years. She is daughter of Premlata. The girl was 4
He,
years
Premlata is the
Deceased.
natural born daughter of his elder brother.
Elder
He
brother.
adopted. He adopted, isn't he?
Yes, Your Lordship. The girl was 4 years old when Premlata died. Lordship, the marriage was for 3 years. The marriage period is 3 years. And he stated that the girl was 4 years old when Premlata died.
How good.
He lacks basic knowledge about his daughter, the deceased.
Then ultimately what is your case is contradiction for the
Contradictions.
evidence of these
Witnesses.
and trustworthiness of PW 9. This is whole
And
Not-
there is
Is-
no demand, my lord. The cycle and radio was given as without any demand. With
gold
this
chain, gold
chain, there is
gold ring
nothing-
and chain.
neither in the 161, neither in the FIR matter. This is developed matter.
But whatever, but these
Yes.
witnesses, how will you discredit these witnesses? All of them are in unison, they are saying.
But in the PW5 is saying neither the PW, the father, nor adoptive father, allege anything.
These are the
Yes.
aberrations you are
Yes.
pointing out, because in UD case, when UD case was registered,
Yes.
these people have never complained
complained.
regarding anything. But the UD case was in a different context.
If anything is found marriage regarding dowry or anything,
What is the period
the
undergone?
period undergone marriage, the
91 days.
the husband.
91 days.
Yes.
What is the sentence?
1
year.
year.
Have you read the judgment, yesterday's judgment of Supreme Court? This is Sanjay Karol's judgment. Have you read it?
No, Lordship. I'll
Read it and come tomorrow.
No,
Day after. Read that judgment.
all right.
And now some guidelines are given insofar as 498A and 304B and all are concerned. Read that judgment.
I'm with
Yesterday or day before yesterday's judgment. Just go through and
I'm
you'll get
with
some idea about how to
two
go about.
judgments married. The one is Wasim and another is.
I'm talking about yesterday's judgment. Let him read. Let her read.
The case number as.
She'll get a clear idea about 498A.
Yes.
You read that judgment.
Lordship.
And I'll hold it for Thursday. Okay. Read the judgment and prepare the contradiction which you are pointing out. Structured in.
Lordship.
Okay. Thursday, yeah? Thursday. Find out from live law or somewhere that judgment is there.
Yes,
Yesterday is Justice Sanjay Korol's judgment.
My lord, item 14, my lord.
14:14, sir.
My lord.
Yes.
My power is there, I'll do it. 30 years back, I have to collect the document. Your lordship may adjourn the case for today.
Because your senior's name is there.
I had. He was my senior.
Okay. 95, but I'll Thursday?
Thursday, next Thursday.
No, coming Thursday. Let it be on 23rd. 23rd.
Yeah.
23rd, huh? 23rd it will be. On the request of Mr. Mishra, please the matter on 23rd. Mr. Tripathi, please proceed. Okay. 23rd, okay. Yes, any small matters? Anybody is there?
21.
21, yes.
Yes, 21, the conviction is one under 1 year for the offense under section 147, 148, and 2 years for the offense under section 324 with 146. This was a free fight between two groups in the village, my lords. The injuries have been
Cross
sustained
affair is
by-
there?
No, my lords. Cross affair is not there, but the defense, they have examined the doctor where the accused persons have been also severely injured, which has come up on record, my lords. But the learned court...
Was it explained? The accused persons received injury, it has been explained by the witnesses.
My lords, the defense witness has been examined as a doctor who is DW2, who has actually...
No, I'm
gone through
asking this question because one of my judgment where I said that if there are free fight, if the accused persons have received injury, the injured witnesses examined by the prosecution has to explain how the injury has caused to the accused person. If they don't explain that, then their evidence is tilted with doubt.
That they have not, as far as I could go through, my lords, that they have not stated. Because the judgment starts with the first para. Thus, it is crucial to find out if any parties are really the aggressor or the occurrence is in nature of a free fight between them. It has been clearly established by the prosecution party members belonging to scheduled caste community, whereas the accused...
How many
party
of you are
belongs-
there?
There are around 9 to 12.
10 others, 10
Yes, my
people,
lord.
11 people.
Who have abated in the meantime. Two appellants have abated, that is appellant number 5 and 6.
Appellant 5 and 6.
And charges were framed under both 147 and 148. And conviction is under 148, although no separate sentence has been passed under 147. Because rioting as well as rioting with deadly weapons.
Conviction is under
147, 148, 324, 149 of the IPC. And
325.
324.
325.
324 minutes. Both 147 and 148.
Yes.
And so far as the judgment reveals, the learned court below has entirely discredited the defense evidence. That the appellants had also sustained injuries, which is, well, Lordship may kindly go through the evidence of DW2, who is one doctor.
Tell me who are the injured witnesses?
Because all the prosecution witnesses are injured witnesses.
And then
129.
who has taken the name of which accused has to be?
That is the discrepancy. In chief, they say that they have been assaulted, but the injuries which they have sustained is not corroborating with the medical injury, that is the doctor.
That's what, see, since there are 11 accused person, you have to prepare a chart saying that PW1 has taken the name of these witnesses. Let us sort it out. If witnesses have not taken the name of, for example, XYZ, we will remove them first of all. Then the corresponding injuries. That chart you have to prepare because there are many accused.
My lord.
Unless you prepare that chart, I don't think it will be possible. 11th witness.
In any event, Willard, the people are not responding.
Therefore, you have to do. Therefore, you have to do it more carefully. Now, after conviction is upheld, then they'll come to you. Just prepare a chart in such a manner that PW1 has taken the name of
Again.
which witness. PW2
And what is the
and corresponding injury by the
corresponding
doctor.
injury and assault?
We sort it out and immediately we'll see that and then it is done.
I'll do that.
It is done. You need not further, labor on that. Reading every witness is not required. You see the chart and finish it up.
There is another matter that is 23. There is a noting that I have already, the hearing was completed. I have filed my written notes of submission. Only the state was to reply.
Which one? 23. Who was appearing for state?
Your lordship may see the noting.
23. Oh. You prepare the chart and read me. 21 video. Mr. Konda, the counsel for the appellant, submits that he will prepare a chart for the witnesses, the injured witnesses, those who have taken the name of the acute person, and the corresponding injuries sustained by that. Yes.
The lordship is posting it to madam.
It will remain. The day you prepare and give me, I'll take it up.
I'll take 2-3 days.
Yes, yes. 23rd, I'll take it.
Okay.
Item 23, you said.
23 again noting, the pleadings were complete. Your lordship had also heard it. I had filed my written notes, and my learned senior for the state was to reply back to the written notes.
23 item,
Again. 23, it is stated, state to submit reply to the written notes filed by the counsel for appellant. Here, admittedly, appellant number 1 is that if at all the allegation suffices, it is against the appellant number 1 for the demand is concerned. The number 2 is the mother-in-law who is on the
for the
deathbed.
state. It's part heard. I've heard him. For state, it was adjourned. Who was hearing? Yes, Manti, Mr. Manti. Yes, sir. Huh? Written note he has given, na? Yes, Ms. Manti, you item 23. He has given written note of submission. He has argued also. It was urgent because you said that you will file written note of submission. Twenty-three. Thursday, written note of submission you give so that I will.
So that if any reply is to be given, I'll file it within a.
Because he has already given written note of submission. You take it 2-3 pages only. You can take it and.
I had supplied my learned senior.
Yes, yes, please give. It's okay. Yes, any matter? Small matter, I'll take it up.
Minus item 20 is for section 376 conviction, 7 years. So your lordship was saying small matters, so I was not.
According to you, it is small or big?
This is big, sir. 7 years that offense serious is big.
Because before vacation, I want to see here only small matters. Small matters, because otherwise it will be a burden making. Small matter which I can dictate and finish it up.
Your Lordship, item 62. Conviction for 2 months, Your Lordship.
Only 2 months.
Only 2
It can be heard. And
21 days
likewise,
21 days undergone.
already undergone.
21 days undergone, your lordship.
Yes, I'll 12:15, I'll come and hear it, get ready. And what else?
Your lordship,
I'll let it be there. 29.
Item 52, your lordships. 6 months of conviction for 323, your lordship. Your lordship has partly heard this matter. For
Get
the-
ready, 12:30. I'll hear
Yes,
it.
your lordship.
62 and 52? 52. Okay, I think. Okay, I'll just come.
20.
Yes. 52. 50? 52, item 52? 52.
May I please, your lordships? May I please, your lordships?
Yes.
I'm appearing on behalf of my senior Mr. Chand, your lordships. It's a matter of 323 conviction, your lordships. Your lordships has heard this matter. There were 5 witnesses.
I've heard this.
Yes,
matter.
Your Lordships. Your Lordship has partly heard this matter.
You are Ashit Behra.
Ashrit Bara, yes, Your Lordships.
But last date of hearing, why you didn't appear?
Your Lordships, my grandfather died. My Bade Papa died, Your Lordships. So I had to run.
Sure.
Your Lordships.
Suji.
Lordships.
Yes, tell me.
The Lordships has
What
directed
was
me
it?
to produce some judgments
Ah.
as to the whether a conviction under 323 can lie when there is no injury report as to what the injuries are, and whether the the
Because
suspected
the
conviction
doctor has not been examined.
doctor has not been
And,
examined. IO has also not been examined, Your Lordship.
IO not examined, doctor not examined.
Yes, Your Lordships.
And whether the injury report is exhibited.
No, Your Lordships.
Huh?
I'm producing a judgment, Your Lordships.
Injury report is also not exhibited.
Not.
Very nice. Yes, madam. No, it's all right. But the question which I pose is, in the absence of medical report brought on record, or the doctor not examined, or the IO is also not examined, how have you established the injury? It could be a simple injury. It could be who is the injured here?
Your Lordships, injured is
PW? There are two injured. Not sure about.
not sure about the.
There are only 5 witnesses.
Only
Of
5
that are, you don't know who is injured. Who is injured?
I'm placing it. PW1 and PW4, Your Lordships. PW1 and PW4, Your Lordships. The PW4 is the husband of the victim.
Who is injured?
blind,
I'm
Your
asking
Lordships.
who is injured. PW1
PW1 and PW4, Your Lordships.
accused persons assaulted me and my husband
Yes, sir.
with stick. They tore my clothes and abuse, as in the filthy language. My husband, who is You've done well. Yes. Yes, next is 62.
para 11 এ লেখা আছে HCST जो discharge আছে সেটা আমি রফলি জজমেন্ট
Let's see, I'll see. 62.
Item 62.
Yes, madam.
Your lordship was appointed her amicus curiae, but you said this, if your lordship.
Please prepare, you have been, you're
I
going
also
to be
prepare, if your
getting
lordship allow me to press, I will press, otherwise you will.
place thereafter you substitute and take her name, huh? There are couple of matters I am appointing you as a matter. Yes. Yes.
Your lordship,
What is the evidence?
lordship,
Offense under?
offense under section 342 of IPC and 323 of IPC, your lordship, and conviction is your 2 years of 2 months. 2 months of conviction, your
What
lordship.
is the prosecution story?
I'd say
Yes.
that on 17/7/2004, that one Haraprasad Sahu, the forest guard, recovered the axe and some logs from the accused person and some other person. There are total 9 accused person. During
How many of them are convicted?
convicted 1 year.
convicted,
Nero.
only 1, but 2 to 9 are acquitted during trial.
Achha.
Only 1 person come to the High Court, and that conviction, there are 12 witnesses. One is PW 1 to 5 are hostile declared,
Yes.
and PW 6 and 7 and 11
Who
are
is the injured?
Injured is the forest guard, that is PW 9, Haraprasad Sahu.
He is injured, huh? Yes.
And your lordship, I will and the PW 6, 7 and 11 are doctors.
PW9 has taken the name of Nero.
Yes, yours.
Yes. Accused Nero began. Came with one of those culprits, and accused Nero began abused. Yes.
May I be permitted to make my submission?
Here, you come to Nero. Nero.
Your lordship, I have 3 points to make the submissions. The first is, your lordship, failure to prove that there is total restraint under section 342 does not, 342 of IPC does not establish over here. Your lordship, come to page number 28, page number 20, PW8.
PW?
PW8, page number 28, if I'm correct. Page 28.
Yeah.
More paper book nine.
Page 75 of the TCR.
Yes, PW8.
Yes, Your Lordship, kindly come to the next page.
He is a eyewitness.
Yes, Your Lordship, eyewitness and injured person. He's a forester, Your Lordship, PW8, and he's the informant as well.
Okay.
Your Lordship, come to the next page of PW8 witness, paragraph 5. Paragraph 5, that the accused Nirod Bhuya challenged him, forest guard Haraprasad Sahu, as to why he has detecting forest offenses, and thereafter he assaulted the forest guard by a blunt side of Tangia, as a result of which the forest guard sustained the aforesaid bleeding injury on his nose. Then I shifted him on my motorcycle in the direction to the Kinjalingi Forest Beat House. The village Devli comes on the way. At village Devli on the road, the accused Nirod Bhuya and 30 to 40% restrained us to move, confined us, taken away the key of the motorcycle, and also forcibly pulled away my motorcycle. Then the accused Nirod Bhuya caught hold of my collars of my official shirt uniform and dragged me to the mid of the village. Your Lordship, if we understand the definition of wrongful restraint, then there has to be a confined area where there is no means to escape. But Your Lordship, here it says mid of the village, which says mid of the village is the open area where they have the chance to escape from the particular
Now,
place.
before that, which you read,
Yes,
he
sir.
says that he says that he was assaulted. He assaulted the forest guard. Forest guard. That is PW9 you said.
PW9, Your Lordship.
Okay. Proceed. Yes.
The other accused person also dragged my 2 forest guards above mentioned to the mid of the village. They confined us there for 4 hours, and during such confinement, the accused person threatened us to kill, Your Lordship.
Accused
Now-
also gave me a slap and on the head and so also. Yes.
Yes, Your Lordship. Now, Your Lordship, PW9, page.
Next PW9.
Page 81.
Yes.
Your Lordship, the last line, first page, last line. I snatch away 1 X from the hand of one culprit. Before he could be able to, he flew away. While I was searching for the forest product, accused Nirod Bhuya came with one of those culprit, and accused Nirod Bhuya abused me in the obscene language and snatched away the X from my hand, and with the X he made a movement on his hand, as a result of which the blunt portion of the tangia hit my nose, causing bleeding injury. Your Lordship, there is no intention, it says.
There is no assault also.
Also, look, injury.
There is no assault. Where is the assault? PW8 says that the guard was assaulted by Niro.
Yes, sir, yes, sir.
And the guard himself says that while pulling that, the blunt side has caused the. There is no blow given by him.
Yes, Your Lordship, there is no snatching.
Where is it?
Sorry, Your Lordship,
It
it's
is
snatching the incident.
by
happened.
snatching in the sense.
The incident happened. There was no intention at all. Mens rea is not there, Your Lordship. Now, Your Lordship, come to.
So there is no. You can very well say that there is no assault made.
Yes, Your Lordship.
That's not time. You have snatched the X from this person. That means.
But where is the assault? Bajile the assault. Read 323.
Yes, sir.
Read 323. You are very senior lawyer. You don't need books. You have everything on your tips. At least for prosecution side, keep some barrack here.
Yeah.
Keep it here.
All the books of the
323. And sometimes the very common provisions you generally avoid reading. 323, read it.
Yes, sir. Punishment for voluntary causing hurt. Whoever except in the case provided for it.
What does it say? Punishment for voluntarily causing hurt. Where is the voluntary causing hurt while pulling it and he got hurt? Anyway, read it. Whoever accepts the case provided under
This
Section
case provided
334.
for Section
Voluntarily causing death.
shall be
Voluntarily causing death by hurt shall be punishable so and so. This element is missing here. Yes. Next, read it.
Your Lordship, the same page,
Hmm.
1, 2, 3, 12.
Read it. Why?
Village Devdi came on the way and we found the accused Nirod Bhuya and 40-50 person
Yes.
were standing on the road. They stopped our motorcycle, snatched away the key of the motorcycle, and thereafter dragged us to the mid of the village. Your Lordship, here it says dragging to them to the mid of the village. That doesn't falls under a wrongful confinement. There has to be some enclosed circle where they don't have any means to escape.
Read the provision.
Yes, Your Lordship. Now, Your Lordship,
Read the provision. Give the book. He is also senior now. Not holding books. Yes.
sorry, Your Lordship.
342.
42.
Read it.
Punishment for wrongful confinement. Your Lordship, wrongful restraint is 339, Your Lordship.
339.
The definition.
Yes.
Whosoever voluntarily obstruct any person so as to prevent that the person from proceeding in any direction in which that person has a right to proceed is said wrongfully to restrain that person.
Exceptions. Obstructions of
Except-
private way.
Private way
Land,
over land
water,
or water, which a person is good faith believes himself to have a lawful right to obstruct is not an offense within the meaning of this section.
Then what do you say? In the mid of the village, so therefore is not wrongfully said.
Your Lordship, mid of the village, and there is a means of escape. They are not confined with an enclosed circle. So there is a way to escape. They are not confined in a particular room or any area where they don't
You
have. any-
restrained, you don't allow him to go either in the house, either in the road, or either in the village, whatever.
But also, Your Lordship, there is a contradictions in IO statement. Your
That's a
Lordship,
different story. We'll go into that.
Hmm.
But it can be said to be a confinement. Because maybe in the village or.
PW10 is also the another forest guard who contradict, who said, who does not support the prosecution case. He said ki no, this type of
PW 10.
10. Another forest guard.
Where does he see?
PW10, the page number.
Which para, madam?
Your Lordship, the first
Not the
para.
fact that I stated before the IO that the confinement of the accused Nirubia gave slap to forest. Yes. Where? PW 10.
PW10, Your Lordship, the
Page 20, the lawyer and defense lawyer.
Which paragraph?
That was in the, that,
Cross examination you are reading or what?
yes, my lord.
Yes.
No,
Yes.
I read the judgment, not cross-examination.
No, I'm on the evidence itself. Read the evidence. Yes, madam, read the evidence. Let us see. Judgment, obviously you find fault with the judgment. Let us see.
Yes, Your Lordship.
Yes.
What? Should I?
Read the
Yes.
PW 9, 10.
PW10
To full.
from the first paragraph,
Yes.
Your Lordship. On 17/7/04, I was working as a forest guard of Lavanya Forest, coming under Malkangiri Forest Range. I know accused Nirod Bhuya only, and I don't know the other accused person standing in the dock. On that day, at about 5 p.m., after dispatching the teak and cashew seedings for the plantation, I, as well as the forester, are going to
Kisling.
on the motorcycle of the forester. We both returned from Kinjaling, and while going towards the Garabandha, we stopped our motorcycle in the village Deula. On seeing the villagers on the ground, on the road, who have demanded seedlings to be planted in their respective baris, the forester told him that it was evening time, and so to advise those villagers to hold the village meeting another day. Thereafter, we both came to Gandharva, and then I went to my Lavanya beat house. The Gandharva police has not at all examined me during the investigation, Your Lordship.
He is declared hostile.
Now, Your Lordship, come to Para 2. It is not a fact that I have stated the IO that on 17/7/04 at 5 p.m. at Lingipur crossing, we found the forest guard, Haraprasad, was standing on the side of the road with a bleeding nose and told us that the accused Narod Bhoya assaulted him. And then thereafter, we shifted Haraprasad on the said motorcycle for medical treatment, but on the way near village Deole, all the accused persons forcibly stopped our motorcycle, snatch away the key and motorcycle, dragged us to the middle of the village, and that they assaulted us and even tried to threshold the forest guard and forester, and that during the process of the assault, they forcibly take away our signature of the four blank papers. And till 10 p.m. the night they confined us. It is not the fact, Your Lordship.
Then PW10 doesn't say anything. That didn't help you.
Yes, Your Lordship.
Who is the doctor who has examined PW9?
PW6 is the doctor.
6 doctor. Rasi 6. 6. Here.
He examined one.
PW9, what is the name of PW9?
9 Haraprasad Sahu.
Haraprasad.
PW6 examined the first.
Haraprasad, yes. Haraprasad Sahu.
He finds one contusion, 1 into 3 cm into 1 cm just below the left lower eyelid. The injury is simple in nature and might have been caused by hard blunt object within 6 to 12 hours of the examination.
The blunt object is his. The blunt side up for the axe.
Thank you.
But there was he has not given the blow.
Pardon?
He has not given the blow that PW9 has said. He has not given the blow. It was only in the scuffle he got hurt.
From the PW6, that there are injuries on the body of the person. Now the only question is that whether that has been caused by the appellant deliberately.
Who will tell?
I'll submit to you. There is one PW8 is the injured, PW9 is the eyewitness.
No. Reverse.
9 is also injured.
8 is the eyewitness, 9 is the injured.
Stunt test.
8 says that 9 got injured.
Yes, sir.
Assaulted by PW accused. 9 himself says there is no assault. When the pull and push was going on, I got hurt.
I'll just place for a moment. PW6 says there are injuries.
Injuries are there, no problem. Simple injury.
I'll just place section 322 for a moment.
320.
May I read?
Yes.
Whoever voluntarily causes hurt, if the hurt which he 321 euros. I stand 321.
Yes.
Whoever does any act with the intention of thereby causing hurt to any person, or with the knowledge that he is likely thereby to cause.
Being push, was he having the knowledge?
I'll just.
The reverse is also true. The person who was the PW9 who was pulling, he has all the knowledge. The accused may get hurt. Reverse is that true?
No, reverse is. I will come to the evidence thereafter. I'll just read it. Or knows himself, or with the knowledge that he is likely thereby to cause hurt to any person and does thereby cause hurt to any person called voluntarily causing hurt.
Yes.
I'll place PW8 for a moment.
8 says I have seen it.
Okay, PW9.
9, I am worried about 9.
9.
8 says that he has given.
Yes.
8, no.
Reread the PW9.
9, read it. Yes.
I'll start with the 5 line from the top. I went alone. I'll start with
9, na?
Yes.
Yes. Yes.
I went alone, Your Lordship, but I went alone on the road to Lingipur.
No, you read the last line. I snatch away what she has read it out. I snatch away the axe from the hands of one culprit. Axe was taken by him. Thereafter, the
You said the
push and pull.
You said the knowledge or the intention has to be grabbed under the fact and circumstance.
Yes.
I'll just place from the I went alone.
Hmm.
I went alone on the road of Lingipur crossing because there is that is in
Where are you reading, madam?
paragraph
Page 81.
page 81, 5 lines from the top.
Schedule 9.
PW9, the first page, second page.
First
First page.
First page.
5 lines from the top.
I went alone, huh?
I
To the road?
on the road to Lingipur crossing because that is the nearest point of approach from the forest area. I saw 2 unknown persons were transporting forest produce. I chased them in order to catch hold of them, but they threw away the forest produce and tried to conceal under some bushes. I snatched away one axe from the hands of the
See, the 2% those who are going away,
Yes,
Nero is not among one of them.
Yes, sir.
Okay? They were someone else.
Yes, sir.
Hmm.
I snatched away an axe from the hand of one culprit before able to
You could
flee
flee
away. While I was searching for the forest produce, accused Niro Bhuya came with one of those culprit and accused Niro Bhuya abused me in obscene language and snatched away the axe from my hand, and with that axe he made a movement of his hand, as a result of which the blunt portion of the tank
Because the same axe was taken away by PW9 from one of the culprits.
Yes.
He wanted to take it back.
Had-
Therefore, he snatched it.
things.
After the snatch.
Read it.
Abused,
Read it.
he came, he abused,
Right.
and made such kind of movement that it hit the injured. That is my assumption. He knew what he is doing.
Very
He
critical
abused-
analysis you are making.
that is. I'll just reread
If
it.
you imagine a situation when the last line he says, I snatched away one axe from the hands of the culprit. While snatching away,
Yes.
if any injury would have caused to the culprit, what would have happened?
Your Lordship,
That was also a dangerous thing. Snatching a axe.
absolutely not. Your Lordship, kindly understand. PW9 is a forest officer. He was.
Does it say that the movement was made in such a manner
Yes, Your
that
Lordship.
it
Yes.
might have caused the injury?
Yes, Your Lordship. I'll just reread the sentence, Your Lordship.
Yes.
Accused Niro Bhuya came with one of those culprit and accused Niro Bhuya abused me in the obscene language and snatched away the axe from my hand. Had it been there, couldn't have been secondary, so apart from the 294.
Then he would have been statue after that, thereafter.
With that, he made a movement of his hand, as a result of which the blunt portion of the tangia hit my nose. There are 3 things. He abused, then he snatched away the axe.
After
then
that,
some,
you said.
but which hurt the injured. That is as
You have
Your
very
Lordship.
critically analyzed, but it could have been 294. Abusing in public place and all, I can understand.
could not have been, Your Lordship. There are no person present.
Assault has to be volunteer.
Your Lordship, assault is volunteer since.
A movement made by the accused for snatching away the axe. In that process, if somebody is hurt, it is not volunteer.
Just reread the sentence.
I read it many times. I underlined many times.
And snatched away the axe from my hand, and with that,
So there
he
is
made
two
movement.
Snatching, this is a usual process. If you snatch it, there should be a movement only.
So then
If in that process, if somebody is hurt,
went after snatching. Had it
after snatching, he will be statue or what? Obviously, the movement will be there.
I made
Your
some
Lordship,
I snatched away the
Your
axe,
Lordship,
there
can
is-
I-
there-
323 is not.
Your Lordship, can I make a submission in a regional language if you permit me? ଓଡ଼ିଆରେ ଏଟା କୁହାଯିବ ସେ ଟାଙ୍ଗିଆଟାକୁ ଧରିକି
ଟଣା ଉଟରା କରୁଛି।
ଟଣା ଉଟରା କରିକି ମୁଭମେଣ୍ଟ
ବାଜିଗଲା।
କରିଦେଲା।
That is what
ଧରିକି
is
movement
the
କଲା।
sense.
ଆଗେ ଛିଡ଼
Your Lordship,
ଠିକ ନେଇଗଲା
Lordship, if you move it forward,
ସେଇଟା ସବୁ ଦିଟା ଅଲଗା ଅଲଗା
ଗାଡ଼ି ଦେଲା-
Where does it say that obnoxiously he is making movement?
Your Lordship,
Where does it say?
Your Lordship, that doesn't bring any intention.
You can't add sentences into it.
Yes,
What into?
It always-
Mr. Das is trying to put something else.
and ଦିଟା ଅଲଗା ଅଲଗା ଲାଗେ
Not a bad. Lordship, you see, Niro Bhuya abused me in obscene language and snatched away the axe from my hand, and with that axe he made a movement of his hand. As a result, the blood.
And he says that his movement like that, a movement, is a movement, a single movement.
He snatched away the axe.
And a
Then
movement.
He made a movement.
While pushing it, the movement, the force Might have caused the
Why snatching?
volunteerness, it doesn't come out. Yes.
There are 9 accused persons. 2 to 9 are, 2 to 8 are released. Only one of. That was the AI.
Because the Nero, his name is taken, nobody knows the other people.
No, your lordship, there is a AIR 1977 Supreme Court that was 2083. That even some out of several accused persons are acquitted, but one participants are.
If the allegations are very specific against one, it can be singled out.
Yes, my lord. But there is no in this instant case, although the injuries are there in neck, body, nose, face, something, but
Injury on whom?
injury on that forest guard, that
It is single injury. I think single injury.
single injury, only eyesight.
Because of that movement, it might have.
Cross-examination, the doctor said if someone fell on the stone, that type of injury also, but they said only your lordship, ମାନେ ସେମାନେ ଛଡା ଛଡି ହଉଥିଲେ ସେ ଟାଙ୍ଗିଆଟା ବାଜିଲା.
That is what I.
So not.
That is what I gathered from nothing.
I also not seized anything.
But now 341, madam, we wanted to say something on 342.
342, your lordship.
Wrongful confinement.
Your lordship,
If 323 also goes, 342 remains.
your lordship, that is on PW 10, para 2.
Yes.
So, your lordship, the first para itself, we stopped our motorcycle in the village, Deoli, on seeing the villagers on the road who have demanded seedings to be planted in their respective baris. So, baris, the forester told them that it was the evening, so to advise those villagers to hold the village meeting another day. Thereafter, we both came to Gandhaba, and then I went to the Lavanya Bid House, your lordship. Your lordship, here, PW 9 and PW 8 says they have dragged us to the middle of the village, where they have been surrounded by 30 to 40
But according
villagers.
to you, that everything has happened in the village, so therefore it is not wrongful confinement.
Yes, your lordship.
Wrongful confinement means, according to you, has to be taken to the victim to a place where nobody would be there.
There is no your lordship.
You restrict the movement.
You restrict the movement. Your lordship. Now, there is a contradiction with the PW 10 who says that the villagers were there for the meeting to get conducted, your lordship. Now, there is no intention for that particular act, your lordship.
To obstruct the road.
To obstruct the road, your lordship. Now, your lordship, come to para 2. It is not the fact that I have stated to the IO.
Suggestions are made.
Yes, lordship.
That is a suggestion.
I have not stated to the IO that on so and so at 5 p.m. Lingipur crossing, we found the forest guard Hara Prasad was standing on the side of the road with the bleeding nose, and he told us that the accused Nirod Bhuya assaulted him, and that thereafter we shifted Hara Prasad to on the said motorcycle for medical treatment. But on the way near village Deoli, all the accused persons forcibly stopped our motorcycle, snatched away the key of the motorcycle, dragged us to the middle of the village, and that they assaulted us and even tried to throttle the forest guard and forester, that during the process of the assault, they forcibly take away our signature on the 4 blank papers, your lordship. So, your lordship, here PW 8 and PW 9 have a different story. PW 10 has a different
There are
story.
contradictions.
Contradiction, your lordship.
Your lordship, for PW 10, can you see the judgment? Can you see the judgment page 22?
He was reading that. You were reading that. PW 10.
Wait,
Which paragraph, sir?
para 13. 13 no end, 14 no just purbo page. Page 22 of the memo.
20, 13. No paragraph here.
13 no.
Paragraphs are not there. Yeah, 13, yes.
13 no the 3 number page.
Read para 13.
para 13 sir ek ଦୁଇ third fourth tar fifth page ko asiya page 22 लिखाई दीजिए
हाँ हाँ yes
last ek ଦୁଇ तीन चार पांच last or sixth line similarly in the case of Pidol 10
this is therefore page 22
page 22
after
yes.
that judgment
After that last
after that judgment Anil Singh reported in so and so
again
yes read it
similarly in the case of Pidol 10 similarly in the case of Pidol 10 Lalmon Misal I find that after retirement from government service as forest guard he becomes a person of village Guma under Sarango PS which is quite adjoining in the Garuda area where the accused persons live. After retirement from the government service, it is quite expectable that this witness lost his credit worthiness and becomes one easy prey to the accused persons. When the Pidol 10 clearly admitted that he was all along present with the Pidol 8, forester up to Kinchilingi square and then up to village Devula while he remained silent regarding the subsequent incident is best known to him. He is declared hostile by the prosecution and even he admitted his signature on the report that is the affair as Exhibit 4/3. He is a literate witness and retired forest guard and does not expect from him that he will sign on the document without knowing the contents thereof. There is a cryptic cross-examination.
So the hostile witnesses evidence is not relied upon because
after his retirement from government service, he has been definitely gained over by the accused person on his locality.
The evidence, I find that the charges under 482 as a whole is established.
Against the accused, yeah.
Okay, what is the period undergone?
21 days.
21 days. But then 342 upheld, 323 acquitted. Already undergone.
161 khalti.
At 161.
Thorred it ekdam solve karo. Thorred sir.
Page 200.
What do you want to say?
Se Odia da sir pura lekha hai pura se pura padhiya gaya.
Read it. He was translating in Oriya what? Read it.
Page 200.
Read it. I'm not going to uphold the conviction on the basis of 161, but still you read it. Yes.
ମୁଁ ଧରିଥିବା allegation ରେ ନୀରବ ଭୂୟାଁ ସେଇ ବ୍ୟକ୍ତିକୁ ମୋଟରସାଇକେଲରେ ବସାଇ ଆସି ମତେ ସାଙ୍ଗେ ସାଙ୍ଗେ ନୀରବ ଭୂୟାଁ ଗାଳି କରି କହିଲେ ସୋଂସ ତୁ କାହାର କେସ୍ କରିପାରିବୁ ନାହିଁ ମୁଁ ଧରିଥିବା ଟାଙ୍ଗିଆଟିକୁ ସେ ମୋ ହାତରୁ ଛଡାଇ ନେଇ
With that.
did not be PW9 he exactly said the same thing in the
No.
commission. Yes. So I'll just again read that sentence.
Maybe English is a poor language, what to do?
Abused my option language and snatched up with an axe from my hand. Full stop. And with that axe, he made a movement of his hand, as a result of which the blunt portion of the tongue hit my nose, causing bleeding injury.
But that part, you can't say that is the intentional movement. But 161, once you read, then you are right there. The movement was deliberately made so as to hurt this. That is what your 161 says. But in that direction, you have not suggested anything. You took it like that. Judges may interpret otherwise also.
Probably trial court.
If the language is such, what to do?
Trial court and the
21 days already undergone. 21 days. 21 days already undergone.
In fact, semane seta suggest kariya the je se movement kortla snatching bale while.
Why should they took the advantage of this now? Why should they clarify?
Two months total conviction है इधर से था 2 months है
अच्छा वो बाकी जो छोटे मैटर wait since both of you have done now handle two lawyers this side, two lawyers that side for such a small matter. Okay, now wait we'll have to appoint you people for a small matter, just see.
Your Lordship, item 60.
I am just calling, see, these small matters,
Okay.
like 6 months and all,
Okay.
it is from item 42, 52 onwards.
Item 50, your lordship, last occasion alerted me to me, that was criminal appeal number 399 of 2006. That was.
You are ready?
Yes.
You ready? Yes, next call. 3, 50, 54.
Item 50. Item 50.
No, 50 is done. I'm talking about the other matter where.
Item 60, जो part है रही थी लास्ट को जो
1 minute, let me call so that
Yes, sir.
query we appoint.
Yes, sir, Lordship.
Youngsters are there, 54. You're there?
323 conviction, your Lordship.
Acha, 54 is there. He is there. Next, 55. Let's see 55. He comes, nobody is there. Nobody is there, 55.
55.
Whose name?
354 and 324 IPC.
No.
And 3
Who is appearing, madam?
I will appear, madam.
Will appear? Pratik Naik, huh? Pratik Naik was appearing. Okay, 55. Yes.
55.
56.
56.
Ajad Khan.
NDPS 6 months.
NDPS, nobody is there. Yes, one thing. You do it. You will do it?
Yes, Lord.
Okay, 55 will put it.
55 done.
55, 56, na?
56.
56 will put it.
55 I'm not.
55 we are doing. 56 you will do. Yes. 57?
57. 5 years.
Hmm?
5 years.
5 years. NDPS వచ్చి 5 years వచ్చి 57.
NDPS 5 years.
Age अधिकार.
Little, huh?
Age अधिकार. 57 61.
How many years standing you have?
13 years.
Then you can do it. She has 13 years. You can do it, huh?
So,
दे दो उनको, huh?
57 done.
57 दो. 58. How many years standing you have, madam? No. 7 years. You?
I, your lordship, 8 years.
8 years, 7 years. You?
5.
5 years. Okay. देख के standing लिख लो, हाँ? बड़ा matter में she is also waiting and देख के you just see depending upon the sentences and all, Mr. Das and she is there, and you give it to youngsters. And I will request you, I am appointing you MA query. I will expect that you prepare your written note of submission and give. Ms. Naik, for you also.
I am there in 55.
No, written note of submission.
Yes, sir. Yes, Lord.
Get written note of submission so that it will be easier. We can cut short the time because see, the vacation is approaching. Now you can take your files and you can very well prepare it, isn't it? Yeah? Okay.
One small mention, your Lordship. Today's item 20. That time I was asking, since it was 7 years, may I be permitted to place it on Thursday or today it will be
It's
taken?
all right, no problem. Whoever is being appointed, please take the paperwork from here and prepare small note.
The
and just
item
check.
45 also may be recorded in my name because it is transferred to me.
40
or 45.
45.
Kadu.
My lord, item 47, my lord, it can be taken up.
Published.
It's a small matter, 324, 2 years, my lord. 2 years are right.
You could come by 2:30 or so
My
because there are 3 matters I have lined up.
My lord.
After that, then I can.
Your Lordship, item 48, your Lordship, NDPS matter, your Lordship, I'll get the TCR copies.
Take it, don't tell. Take it and get ready with the written note of submission
Yes, sir.
so that we can proceed immediately. Okay. Just check it up and you, Mr. Das and Sulakshmi and all of you, just see, help him out so that we can give it, distribute with
Those are smart.
youngsters and so that. Okay.
Lordship,
Item?
Your Lordship, may I be permitted to make a mention? Sure, item 17, Your Lordship has fixed it to 2:30. Can it be a Thursday? Yes, I've already informed. Much obliged.
May I please, Your Lordship?
Yes, Mr. Mahaprabhu.
My Lord, here the petitioner's second.
Why has it come to me?
My Lord, because earlier application, Your Lordship has considered and disposed of very same subject matter. Therefore, the Honorable Court in advance felt it that it will be proper to be heard by Your Lordship.
Yes.
Here, earlier occasion, this matter, background of the case, I'm just explaining. This is a matter concerning of the arising out of a domestic violence proceeding. There were certain directions, as many as 10 directions, expiry orders was issued. And Your Lordship was the order saying that this is an expiry order. However, Your Lordship directed that direction number 2 and 3, that will have to be complied by my client. And also, I was given a liberty to file a petition for variation of those 2 directions. Pursuant to that order, I filed petition for variation. That petition was taken up and for filing of objection, the wife took time. Subsequently, she filed and the proceeding is continuing there. In other case, in case of the execution proceeding, which was filed for execution of the order which has been quashed, in that proceeding, the wife pressed hard. My contention, my lord, in one hand, she is taking adjournment in variation petition, in other hand, in execution proceeding, pressing hard. And
you are appearing
for the opposite.
I have filed this application has been filed with a prayer that execution proceeding be kept in abeyance till the decision in the variation proceeding.
Let us see my order first.
My lord, Your Lordship's order.
Before my lords.
That.
Yes, that you want to like.
Yes, my lords.
Page 7.
Page 22, my lords. The order is there.
No, I'll hear you, but you want to say anything?
Yes, my lords, the execution, my lords, on the last occasion, the learned JMSC has already executed order and the salary has already been attached, my lords.
And that the execution proceeding is not in existence. That I want to say.
No, my lords.
That execution proceeding was 2023.
No, that has already been concluded according to him.
It has been concluded, but kept under.
What do you want now?
No, my lord, here, that's why I'm filing a miscase, because during pendence of this application, Your Lordship kindly have a grants to order.
This application, the execution proceeding went on.
Yes, my lords. My lords, I'll clarify. Let my learned senior complete. I'll clarify the position once.
Yes.
My lord, may kindly see this IA. I have enclosed that order. During pendency of this criminal miscase, what happened?
You'll file it. The registry number is.
जेहेतु weekly list रे अछि सामिल हे परिबोनी बोली मु सेटा को सेट पे रखि देली.
I'll permit you to file it. Okay. What is the order?
My lord, page 8
Yes.
of my present IA.
Yes.
The case record is posted today for payment and further order. Learned counsel for both the sides are present. Before that, going to that, Your Lordship kindly have a glance to the case number and the nomenclature. Criminal execution number 101 of 2023. Why I am giving much importance on this? Because this execution proceeding was filed for execution of the order which has been quashed.
No. Where are you reading? Page 8, that is criminal miscellaneous 4692 of 2025.
No, 101 of 2023.
Page 8 you are reading. IA this one.
Annex 6 lekha hai jeta.
Annex 6 lekha hai ji, okay.
25/11/25 ର order ଟା.
25/11/25 ରେ.
हां ना ता ऊपर टा मु खाली देखौतली खाली केस नंबर टा खाली जस्ट खाली अपन टिके नजर करियो. केस नंबर टा खाली क्रिमिनल एक्जीक्यूशन नंबर 101 of 2023.
हां ठीक है.
This petition was filed prior to Your Lordship previous order. By the previous order, Your Lordship quashed that order. Therefore, what was...
I have not quashed the
exactly
execution. I have quashed the main order, principal order.
And my lords, it was
execution order
retaining two condition, whatever.
Yes.
And I said that you complied, and if you are still agreed, move an application.
Yes. And my lords,
and also that execution was filed for execution of 10 directions.
No, my lords.
It's a different story.
My lords, I'll tell you.
Just as
if I may, my lords.
And what the order was passed on 25/11.
One minute.
Just wait for a minute. I am a petitioner, sir.
Yes.
Your turn will come.
Yes. Where is show me my order.
Your Lordship's
When
order, page 7.
order
Page
is that?
7, I have quoted it.
Page
7 of my criminal miscase.
Page 22 is the annexure, my lords.
No, full text you.
Full text and page 7.
They have
I
annexed it.
Reproduced it by getting it downloaded and copy paste. page 7 of my criminal mischief case.
Yes. Here.
May read from paragraph 4.
Yes.
Mr. Mahapatal on counsel for the petitioner submit that the petitioners had moved an application seeking setting aside the ex parte order against them. He has explained the sufficient reasons regarding his absence for which was mentioned in the
The ex parte
application.
order is regarding maintenance in domestic violence.
Yes, all the 10 directions.
Yes.
Please. That non-appearance of the opposite parties on the date fixed is not intentional, rather caused due to such and such. That has been reproduced. Then your lordship may come that now the opposite parties engaged a new lawyer by disengaging their previous lawyer, and filed this petition before this honorable court. Hence, in this circumstance, the matter may be considered favorably for the opposite party number 1 and 3, and the ex parte order dated 1/9/2023 may be called set aside, and allow the opposite party number 1 and 3 to reduce their evidence and to participate in the proceeding for the interest of justice. That if the said ex parte order dated 1/9 is not set aside, then there will be an irreparable loss injury to opposite party number 1 and 3 and will be highly prejudiced. And on contrary, there will be no loss to the
Honor,
petitioner.
I have perused the ex parte order passed by Lennon Bhubaneswar.
Yes.
153 of 2019.
Operating part of the ex parte order is as follows. Number 1, the respondents are hereby restrained for committing and inflicting any kind of domestic violence upon the aggrieved person, oblique petitioner henceforth. Number 2, the respondent number 1 is directed to pay 10,000 rupees to the petitioner towards the house rent for separate accommodation with effect from the date of this order. Number 3, the respondent number 1 is also
All these directions are there.
Yes.
Then-
And then you will say, I'm paragraph 8, page 10 of this paragraph 8. I am inclined.
To allow the application.
I'm inclined to allow the application of the petitioners, setting aside the ex parte order. This is most important.
Well,
Setting
it has
aside
to
the
be-
ex parte
it has
order.
to be- it has to be read as
Setting ex parte the order only on the ground that
1 minute. See, the best way of doing it, let him complete, thereafter you will do it. Otherwise, you will mess up your case. Have patience, please sit down. You will be called upon. Yes. I am inclined to allow the application of the petitioner setting
aside the ex parte order only on the ground that the series of directions made by the learned court below without affording opportunity to the petitioner. Further, insofar as direction number 2 and 3 as mentioned above are concerned, the same has to be maintained till section 12 of the PWDB Act application is decided afresh while affording opportunity to the petitioners. Accordingly, the petition is partly allowed. Section 12 of the PWDB Act, the petition is filed by the opposite party number 2 is restored to its original file. The learned trial court is directed to decide the application approach by affording sufficient opportunity to the petitioner subject to
Now you come to condition number 2 and 3.
2 and 3. There are condition number 2 and 3 also. You will
2 says 10,000 rupees towards the house rent you have
Yes.
to keep on paying. And 3 is 20,000 rupees
per month
the
towards
household expenses.
Yes.
30,000 rupees you have to keep on paying till section 12 is decided.
No, thereafter what your lordship say? Just paragraph 9.
Yes.
It is open to the petitioner to move appropriate application before the learned trial court for a variation of the direction contained in ex parte order insofar as direction number 2 and 3 is concerned.
You can
So-
ask for variation also.
Yes, I have filed application.
What
for
happened to
variation. That application is continuing because of the non-cooperation of the wife. That is proceeding in before the one court. In another court, in the execution proceeding. What much emphasis I am giving, that execution case was filed for the execution of the order dated 1/9/2023, which has been interfered by your lordship.
But
without
see,
subsequent-
insofar as condition number, direction number 2 and 3 are concerned, these are being maintenance order.
Yes.
I have not interfered.
You
have to comply this.
Yes.
And what I'll do is the application which you have moved
Yes.
for variation of the order.
Yes.
I give a direction for the purpose of deciding it as legend person.
Yes.
As simple as that.
Yes. But the what the court both the because
I will not
proceeding-
interfere insofar as your execution is concerned.
I am not also playing so far the whatever direction you are
I
maintaining,
will only give a
maintaining the
direction
two
to the
directions.
court that insofar as your application which you have moved for
Yes.
variation of condition number 2 and 3 are concerned, that application be heard as early as possible. That's all.
My lord. But till that date execution may not be there.
I will not say.
Because the execution
That's not
calculation
your-
has no what is the order has been passed. Your lordship can let's see.
I will not interfere in execution at all. because it's a maintenance case.
ଏକ୍ଜିକ୍ୟୁସନଟା ପେଜ ଏଇଟା ଟିକେ ଦେଖନ୍ତୁ ଯୋଉଟା କହୁଥିଲି ଟିକେ ଖାଲି ଦେଖ ମାନେ କଣ କହିକି ସେ କଣ କି ଅର୍ଡର କରିଛନ୍ତି ସେଇଟା ଦେଖନ୍ତୁ।
See, in this kind of situation, the matrimonial dispute, generally the court should not interfere in maintenance issue.
ନା ମୁଁ ସେଇ କଥା କହୁନି ମୁଁ
Stretching too far and you bring it
ଟୋଟାଲି
taking
କହୁନି ଯେ ମତେ ଆପଣ ମେଣ୍ଟେନାନ୍ସ ରୁ ଟୋଟାଲ ଛାଡ କରିଦିଅନ୍ତୁ ବୋଲି।
When was this order passed by me?
This order was passed, attachment order on
No.
8/12.
27/11/2024. This
Yes.
is my order.
Yes.
And when have you moved the application for variation? Give me the
Immediately.
date.
No.
Where is this application? Variation
Filing
application.
that immediately.
Annexure 2. Annexure 2.
Annexure 2 ta file.
Annexure 2.
Data ko badlo. 7/4/2025.
7/4/2025.
2025.
September I passed the order.
Yes. Thereafter, I moved modification of that.
Yes.
Modification of that order. Your lordship not interfered. Thereafter, I filed this variation application, and your lordship annexure 3 page.
Because the amount of money you are spending in the litigation, being husband, that much money if you pay, half of your problem is solved.
My lord,
You want to happy litigating,
no, my lord.
going to this court, going to that court, moving application, engaging lawyer, senior lawyer of your stature.
No. Your lordship can never grant to page.
Amount of
Page 8
money
of
is
the act.
spending on, I will not tell, I don't want to get into, but engaging you itself is a, taxing so much for a crime. And this much amount if they'll give to wife, half of your problem is
This
solved.
much amount of 18 ଲକ୍ଷ ଟଙ୍କା ଡାଇରେକ୍ସନ କଲେଣି ତ ଏବେ 18 ଲକ୍ଷ ଆଟାଚ କରିଦେଇଛନ୍ତି
18,000?
18 lakhs 18 ଲକ୍ଷ ଟଙ୍କାର recovery ପାଇଁ
Accumulating.
ପେଜ 8 ଟା ଟିକେ ଦେଖନ୍ତୁ କେମିତି ଅର୍ଡର ହେଇଛି।
Deposit 9 lakh,
How-
I'll interfere.
No, my lord, what the
18 lakh rupees is order. 9 lakh you deposit here, I'll interfere. 50% straight forward. 9 lakh you give, I'll interfere. I'll issue notice, call for 9 lakhs. No negotiation. If you start negotiating, I'll increase. Remember. 9 lakh deposit, I'll. It's after all, wife's maintenance, what are you talking? Yes. 9 lakhs deposit, I'll interfere.
9 ଲକ୍ଷ ଟଙ୍କା କରିପାରିବୁ ବୋଲି ଜାଣି
Out of 18 lakhs, 50% slash. I'll increase, I'll tell you.
with leave.
No. 9
ଲକ୍ଷ ଟଙ୍କା ଏଇଠି
deposit 9 lakhs, we'll see.
ଯାହା entitlement
I'll
ସେ
hear,
ହବ।
I'll stay the execution proceeding subject to depositing 9 lakh rupees here and it should be disbursed to her.
Disbursement order ଟା ନ କରୁ subject to outcome.
What will you, I'll do with the money? I don't need money.
No.
I have salary of mine. She needs the money. Give her.
She also does not need money.
Give her.
Because she has
Try
sufficient
to be
means.
reasonable.
That's why her application has
Try
been
to be
refused on her
reasonable.
point of
After
view.
all, she is your wife. You have to pay something. Not that deposit 9 lakh rupees, 5 lakh rupees will be disbursed and thereafter we'll see. Right away. Subject to the petitioner depositing 9 lakh rupees before this court. Issue notice to respondent. Respondent may file, respondent one, opposite party may file reply within 2 weeks. Out of the 9 lakhs to be deposited before this court by the petitioner, 5 lakhs will be disbursed to the wife, respondent, opposite party number 1, and the remaining 4 lakhs will be invested in a interest-bearing fixed deposit to begin with for 6 months. Subject to compliance of the C condition. The execution proceeding, show me the execution proceeding.
1016 execution proceeding 101 of 2023.
Where is the last order?
Last order 8/12/2025. IR ଅଛି
It is
IR page
order
10
dated, order dated, attachment order.
page 10
Yes.
8/12/2025.
Order dated 8/12/2025 passed by the learned JMFC 3 Bhubaneswar in execution criminal execution petition 101 of 2023 shall remain state. After 2 weeks, place it after 2 weeks. Get ready. Take 5 lakhs, and I'm sending you to mediation. Finish it up. Don't try to be very ambitious.
I was telling my associate, don't call me to that court. Your amount will be increased because
Sometimes it is counterproductive.
I'm grateful, your lord.
Okay. It file this file application. This application you file in the registry filing.
Yes, yes.
Okay. 5 lakh rupees will be released to you. 4 lakhs will be invested in the interest bearing, and thereafter we'll see what can be done.
ଏ ମାସେ ଟାଇମ୍ ଏଇ ମାସକ ଭିତରେ ଡିପୋଜିଟ୍ କରିଦେବ
2 weeks time I am giving. After 2 weeks I will release it.
2 weeks ଦେଇପାରିବନି ମାସେ କରିଦିଅ ଏଇ ମାସକ ଭିତରେ ଡିପୋଜିଟ୍ କରିବ ଡିପୋଜିଟ୍ will be within 1 month.
What was the order there? Attachment order.
ଜାନୁଆରୀରୁ ଇଫେକ୍ଟିଭ ହବ
January same. Same.
ମାନେ ଏତେ ଜାନୁଆରୀ ଡିସେମ୍ବର 31 ହେଲେ ତ ମାତ୍ର 10 ଦିନ ଖଣ୍ଡ ମିଳୁଛି 9 ଲକ୍ଷ ଟଙ୍କା ଦେବାକୁ ପଡିବ ନା
On or before 15th of January. 15th of January. Deposit on or before 15th of January. Lease January 15 January for next date. Any date 15 January.
16 number ଅଛି
No. Give it on 27th.
27
27 January. Okay.
27 January.
Yes.
Item
Yes.
Item 12.
My lord, may I read my lord, para 24 of judgment.
24.
Of judgment. Exhibit 10, 11 and 12 are the letters before such a incident to her parents.
Sir?
To her parents. The victim led
Show me. 24. Read it.
That was in Hindi language, so this has been noted by.
24 of the judgment, huh?
Yes, ma'am. Exhibit 10 is.
Internal page 24.
Internal.
Okay.
Exhibit 10 is an inline letter dated.
Now, where are you reading? Para?
From the beginning, 24, page 24.
Para.
Para 24 and page 42.
42.
Of the paper, yes.
Okay. Exhibit 10.
Exhibit 10 is an inland letter dated 27/2/91, written by the deceased from the house of her in-laws to her mother after the marriage. In pursuance to the prevailing custom, the bride remained in her father's house for a few months, and she was sent to her in-laws house for the first time in February 1991. This letter is dated 27/2/91. And obviously, she wrote it.
When the incident takes place?
Incident takes place, my lord.
Date.
Date of 24/9/91.
24?
9/91.
Yes, proceed now.
This letter is dated 27/2/91. And obviously, when she wrote it a few days thereafter, in the very first para of the letter, she wrote that she became entrapped and that possibly the only way to escape by ending life. She then narrated the that right from the first day of her arrival, the old lady, meaning mother-in-law, and both the sisters of her husband had taken away her peace of mind.
Who have taken peace of mind? Old lady, the mother-in-law, and sister-in-law. No, nothing about husband. Nothing about husband.
But the husband always keeps silent.
That is what I am asking you. Remaining silent is a mens area.
And it is his duty to protect or support his wife, but he has not supported.
You are being a prosecutor, your duty is to assist me. If you don't assist, then you have committed crime. Remain silent. If somebody remain silent, remain silent. Unless you say that deliberately remain silent, in his presence everything was happening, still he remained silent. Those kind of evidence is there. He saw everything. Being husband, he saw everything, that the torture is meted out to his wife by the mother-in-law and sister-in-law and everybody. And he used to see those things. Still he remains silent. In his, behind his back, it might be happening. It might not be communicated to him. Who knows? In his presence, everybody must be behaving very goody-goody. In his absence, she is being tortured. Who knows? This kind of evidence has to be borne on record. That in his presence, if the mother-in-law is torturing her and sister-in-law is torturing her, still he remains silent. It is a deliberate silence. He is lending support to the perpetrators. Therefore, 107.
That part has been disbelieved by the court below. They have not challenged it. 498A, 4DP Act has been disbelieved.
In that particular day, he was also present in that into 5 statement. He was present. The husband was also present.
See, he has been acquitted for 498A. Cruelty is not there on his part. The trial court is not believe your evidence. And therefore acquitted 498A. There is no cruelty, there is no demand of dowry, nothing is there. Therefore, in the absence of that, if you want to bring 306, the only way out for you is 107. 107 IPC, abatement. For the abatement, what are the materials? And that abatement is also to the quick succession, proximity to the incident. Therefore, I asked the date of the incident. The letter was 27/2/1991. Incident takes place in September. There is no proximity.
3 letters, sir.
3 letters are in the none of the letters. The husband is against husband. She has not said anything. Exhibit 9 next paragraph से see exhibit 10 खत्म हो गया. Exhibit 19 the same thing. Her mother-in-law and both the sister husband. Right from the first day of arrival. Exhibit 18, just see what he says. Exhibit 18, para 26. Just see, very interesting. Para 26, read it. Very interesting reading. Read it.
Is an inland letter addressed by the deceased to her mother and dispatched.
The deceased write a letter to her mother saying what? She wrote therein that daily after the departure of her husband for duty, her in-laws are going and nagging her and so on and so on. That means what happens? Everything is behind back of the husband. After, just see, after departure by the husband to the duty, that's what I was telling you. That makes your case worse.
Remaining inside jail, and that till then opportunity had not come to her for enjoying upon air and light.
You come to page, that letter is written here. Exhibit 15, again 27, exhibit 15. Just see in the middle. The old lady, meaning the mother-in-law, has been nagging me every day, but I kept silent. I am to tolerate this every day after his husband, after his, meaning husband, departure for duty.
Paragraph 26,
Reverse.
27, 28, 29. Court has analyzed everything and reached at a conclusion at paragraph 30.
Behind back, everything is happening. If the letter is to be believed.
What's the last portion of case 49 is? The conduct of the husband is very obvious, though he has not been directly subjecting to the deceased.
Where are you reading? 49?
Page 30, palette, concluding.
Hmm.
Para 30, page 49, last portion. The conduct of the husband is very obvious, though he had not been directly subjecting the deceased to the extreme form of cruelty and illiterate treatment. He nevertheless did nothing to, much less to protect her. During the absence of father-in-law and mother-in-law, when the deceased, though getting some peace, the husband misbehaved with her badly.
Very interesting. See, when I confronted, the husband says that the nature of his parents is like that.
And when she would
Not able.
be able to discharge her domestic duties.
No, see, para 30, just read last two, 3 line. In Exhibit 17, the deceased had categorically mentioned that if she would speak to her husband about the ill treatment meted out to her, instead of confronting her, confronting the parents,
He would simply say.
he would simply say that the nature of the parent is like that.
To
This is a
attract.
natural behavior. My parents are like that. What can I do? He is neither here nor there. That is the situation. Huh?
Secular.
The poor guy can't help it. He can't be against the parents, not against the favoring the wife. Where is the culpability? My husband says that I should tolerate everything and continue like this in the house of my in-laws. The conduct of my husband is very obvious. Though he has not directly subjected the deceased to the extreme form of cruelty or ill treatment, he nevertheless did nothing to confront her. Much less to protect her. During the absence of father-in-law and mother-in-law, when the deceased thought of getting some fees, the husband misbehaved with her badly. And even when she was not able to discharge his domestic duties, and even on account of weakness in physical incapacity. Even if this is believed, is it something to do with close proximity to the incident? For bringing 107, the incident is so proximate, some incident, triggering point, so close to the incident that beyond that she could not tolerate. So therefore she committed it. That element has to be there. It is a general ill treatment which is being meted out to her consistently. That could be 498A. He has been acquitted. Where is the close, any triggering incident which is to the close proximity to the, the suicide?
The letter approved by the father of the deceased have been written by the deceased in her own handwriting, and the same content her statement as to the circumstances of the transactions which resulted in her suicidal death. The letters are undisputedly relevant under such circumstances. The fact and conduct reveals that, revealing the evidence of PW 5 and 4 discussed in proceeding para number 2021, the evidence of PW 11 regarding complaint made by the deceased before him and other of his family when she went to her house regarding ill treatment and cruelty meted out to her provide adequate corroboration of and supported regarding truth of the statement made by the deceased in her letters. Undoubtedly, it is mother-in-law who had been namely and actively subjecting the deceased to constant treatment and coercive.
Read 51. 107, he's dealing with 107.
Just trade on that. That means. My lord can see two judgments on this score. My lord.
He invoked 113A.
My lord, here.
51, page 51.
My lord, my lord.
He's invoking 113A.
My lord.
Which is not permissible after recording acquittal. Acquittal 498A, section 4 DP Act. Acquittal is there. So 113A you can't invoke.
That has been clarified.
That is the judgment is there.
Yes, Bharat. Another judgment is I have
Atmaram versus State of Maharashtra.
Yes, Bharat. That is 2013, volume 12. And with regards to 107, Bharat can see also another judgment, 2023, volume 15, SCC 544 by Honorable Justice Vikram. Another case of passing. Why I give it. Passing of the offense investigation under 306.
This is Kamalakar. Which paragraph?
Ballot with regards to 107?
No, this is Justice Vikramnath.
Ballot first, Placitum is such ballot. 2023. As per the prosecution, deceased wife poured kerosene oil on the body and burned herself in her parental home due to increasing of harassment and mental cruelty from her husband and acquitted in-laws. Issue arose whether the prosecution proved the charge under section 306 beyond reasonable doubt. Held to charge someone under 306, the prosecution must not only prove accused played a role in suicide, but specifically the accused actions must align with one of the three criteria detailed in 107, namely accused either encouraged the individual to take their life, conspired with others to ensure the persons committed suicide, or acted in way or failed to act which directly resulted the person's suicide. Further held, instigation is to goad, urge, forward, provoke, incite, or encourage to do an act. And to satisfy the requirement of instigation, though it is not necessary that actual words must be used to that effect, or what constitutes instigation must necessarily and specifically be suggestive of the consequences. Yet, a reasonable certainty to incite the consequence held must be capable of being spelled out, like spelled out. Here, my lord, the court consider everything, and even my lord, 498A was there. But for In our case, 498 is the minimum requirement to attract 113A. Even if 113A not be there, 107 has been taken note of in paragraph 15, my lord, may see.
Yes, read it. Section 306 deals with what thing?
If court was pleased to observe, 498 is there, but acquitted from 306. The essentials of section paragraph 18, my lord.
Paragraph 18.
My lord. The essentials of section 306 IPC were elucidated by this court, M. Mohan so and so, which had to be beaten out in order to bring a case of 306. Also declared. Though my lord, case of 498 was that extreme case, but for that reason I had given the.
Come to para 18. Okay, I was just wondering is the condition 107.
My lord?
And 107.
My lord.
The three conditions which are there.
My lord.
All conditions are or.
My lord.
Either of one condition satisfied in the 107.
My lord.
The second condition says intentionally aids by an act or illegal omission.
My lord.
Doing that act
My
of
lord.
that thing. Okay.
My lord.
Whether illegal omission, silent is an illegal omission or not. That was
My lord.
striking in my mind.
My lord.
Remain silent, knowing that something is bad is going on, is tantamounting to illegal omission.
My lord.
But the word which is suffix is illegal omission.
My lord.
And remain silent is in that illegality.
Illegal.
Immoral omission I can understand. It can't be an illegal.
It's an omission.
It is an omission, maybe immoral. Maybe immoral.
Maybe. To the,
But it can't be
traced.
illegal.
It can be stressed
In
to
that
immoral.
context, I was thinking of, come to para 18 now.
My lord.
Para 18 of this is.
My lord.
And it is reproduced, just para 44. There in the reproduced.
Abatement involves a mental process.
Abatement involves, just read it. Abatement involves
A mental process of instigating a person or intentionally aiding a person in doing of a thing
doing a thing,
without a positive act,
without a positive act on the part of the accused
to instigate or aid
committing suicide,
conviction cannot be sustained.
What is the positive act you are attributing?
The thing.
Remain silent is not a positive act. It is not an act at all. Even if you want to bring it to the deliberate omission,
Paragraph
it is not illegal.
Paragraph 45 is more clear also. The intention of the legislature.
Try to analyze critically, then only you will reach somewhere. Otherwise, just simply reading will not help.
Wife is the only person.
Don't say, argue like a High Court lawyer.
For that reason, I have brought this.
Para 45 again read there. The intention of a legislature and the ratio of the cases decided by this court are clear that in order to convict a person under section 306 IPC, there has to be a clear mens rea to commit the offense. And it is also requires an active act or direct act and which led the deceased to commit the suicide, seeing no option. And this act must have been intended to push the deceased into such a position that he or she commits the suicide. So your act should be very positive. That positive act push a victim to take a step which is an extremely step. That element of the act, a positive act, has to be borne on the evidence. What is the positive act according to you? Your evidence says, even the letter says that in the absence of my husband, my in-laws and sister-in-law and everybody was torturing me and all. And what the only thing what he did is he remained silent. And when the complaint was made to her, made to him, and he says that what can I do? My father and mother are like that. And he has expressed his helplessness. Is expressing helplessness is a positive act according to you? Satisfy 107 condition? He may be a victim because the evidence she herself says that in the letter she writes that the husband expressed helplessness, saying that I can't do anything because my parents are like that. Yes.
It has also been analyzed in a different way by Honorable Justice Nazir, 2021, volume 19, SSC 144. Well, let me see paragraph 12.
I was giving that example. Would see the husband keeps on saying, husband drinks regularly. Wife keeps on saying that if you drink, I'll die. Then while drinking, he says that go and die.
Go and die.
Then he commits suicide.
Well, in very,
And the court says that it's not in a positive way.
yes, that is that distance I have also seen.
Because it was not his intention that you go and take a step. Immediately she goes and commits suicide. The court says that it's not a positive act. So therefore 306 will not. Yes.
Bhakti, let's say.
In our country.
Well, opinion. Yeah, they've analyzed what is suicide, sui, what is sui, what is side.
Sui is self, side is killing, suicide. And in this context, you read when the Justice Sancharya declared 109.
There also it has taken note.
There's very interesting judgment. You must read that.
309.
309. Justice Sancharya's judgment you must read.
306 and 309, my lord, there is a precedent there in that case.
Very beautifully narrated this thing. Judgment. You must read that. Yes. What will you say? What to do? These are the situation. You want to add anything?
No, sir. No.
Okay, these judgments are very, very clear judgments and very difficult. The evidence is no evidence at all. Rather, the evidence is contrary to the interest of the prosecution. Anyway, but sister, mother-in-law and sister-in-law, foolproof case. Foolproof case.
Both
He could not have defended. Otherwise, it's a
clear case.
100%.
Clear case.
Nobody could have saved her.
Yes, I was going through the. I've taken the copy of the letters. Tried to read, but it was in Hindi.
But translated form is reproducing the judgment itself. And there he has said, once the husband goes for duty and these people harass me. Harassment is also not in the presence of husband. And when he comes back, when she says, these people are harassing me, he said, what can I do? I can't help because my parents are like that.
But your lordship, the husband duty is at least ask the parents even.
Duty is not enforceable. Moral duty is not enforceable. Moral duties are never enforceable.
Next time.
What can you do? Every son has a duty to look after the parents.
Yes, sir.
They don't do it. What? There is a legislation block. But even then, nothing is done. But criminality you can't find.
Yes, sir.
Unless injury is done.
Hmm.
Unless injury is done, you can't get mention. Some injury, mental, physical, financial injury has to be there
Yes, sir.
to bring criminal act. Injury.
Right.
There is no injury. Remaining silent is no injury in any aspect. Yes. Duty of a son is to take care of parents. But if the son says that I'll go and stay somewhere else, that's not illegal. But if the husband, if the parent says that he's not paying me maintenance, then physical, financial injury cause, then the act comes into play.
Yes, yes.
If the father has no demand,
Yes.
you can't force that the son has to come and stay with me, or he's staying away.
Yeah.
There is no illegality there.
Yes. Yes.
So that is how you have to read the provisions. Yes. Next.
Next.
You got exhausted. You can't answer it.
Tuesday, Thursday.
Okay, Thursday. Yeah?
Thursday, Tuesday.
Tuesday. Okay. Report is due.
Thursday, I have to, I will remain busy.
Tuesday.
Item the 15, 16 is there also. We'll do it.
15, 16. No.
Huh? Asini.
You are appearing 15?
15 report asini. Dekla.
No, TCR not received in 15.
Yes, 16.
I have called for the report. 16. Hmm.
16-year loss with 326, 307. 5 years of conviction and 1,000 rupees fine, and for 324, 1 year conviction.
कर दो Nice.
यार बड़ोटे अच्छी थी सर, अच्छी 10 टाइम वेट नहीं थी गुरुवार को सर
You have to read Thursday.
ठीक है सर को करिए
Tuesday सब कर दो अब 4-5 अच्छी वो कर दो सब
eyewitness is there, injury is there.
Which one? Which one?
This one, age of 16 years.
16, huh?
I have 5 years of conviction.
I have got other matters 17, sorry 15, 16, 31, 45. चार्टा का था वो मंगलवार कर दे
ठीक है मंगलवार चार्टा रख दियो चार्टा ठीक है
Item number 27, I think they have taken time. Government of Bill. So 13, 15, 16, 31, 45.
Because they are not matching with the preparation. You have to prepare and come because see these are old matters. You decide how to go about it.
13,
15, 16, 31, 45.
You divide among them yourself and get ready. Yes. Report, huh? 54
Be permitted to appear on behalf of my senior lordships.
54, huh?
Yes, your lordships. Item 54. Lordships, this is a conviction under section 323 of the IPC. Same, your lordships, sentenced for 6 months of imprisonment. The appellant has been in custody for 9 days.
9 days.
Lordships, the prosecution has examined
8 witnesses,
Hmm.
where the sole reason of conviction was PW 5, 6, 7, accompanied with the injury report, Your Lordships. The 5 is the informant, the father of the injured. 6 is
Who is
the
injured?
injured is PW 7, Your Lordships.
EW?
7.
You show me injured and the doctor's evidence.
Yes, Your Lordship.
EW 7, read EW. 323 conviction.
Yeah, noted, Your Lordships.
You are Sanjay Kumar Tripathi. Me too.
Lordships, this case has a backstory, Your Lordships. The alleged appellant has attacked the injured on a relevant day when the injured himself was going to give statement against the accused in another case. Lordships, there has been a previous dispute among the family members of the injured as well between the appellant. And to give the younger brother of the injured has given a case against the appellant. Subsequently, the police has called the appellant, Your Lordship, the injured, to give statement.
Yes.
On the way, while he was going in a bicycle, the injured has attacked him by the means of a lathi. I want to press this part. They have not seized the lathi, neither the cycle. And admittedly, there are
You
injuries.
show me the injured witness, what he says regarding you, and show me the doctor,
Yes.
whether it corresponds to the injury or not.
Yes, Your Lordship.
Yes.
PW 7, Your Lordship.
Yes. Where does he say? Where he has taken your name?
PW 7. PW 7, Your Lordship. Bookmark is there.
Proceeding to the outpost, so the accused all of a sudden detained me by holding my cycle, asked me why I was going to outpost, demanding 2,000 rupees, causing the fire against him. Also, at the outpost, why my brother, PW6, Rashid Kumar Das, and I refused the accused assaulted me while laughing. I sustained injury and left side eye broke. Who is doctor?
Doctor is PW 4, Your Lordship. He has bruises over left forearm, right thigh, left thigh, left outer.
Thigh.
Canthus of eye.
Eye injury is also there.
Your Lordships?
Injury on eye is there.
Yes, Your Lordship.
Yes.
Yes, Your Lordships. Lordships may see the FIR. They have stated that the father of the injured himself has stated that his son has sustained injuries on the Munda, Pitti, Hatha and Goda. I am not disputing about the Hatha and Goda. Munda and Pitti, there are no injuries. And admittedly, there were 3 persons who have seen the occurrence, but they have turned hostage. PW 1, 2, 3.
But why should I doubt 7 and 4?
I'll place this, Your Lordship.
7 has said that you have
yes.
Detained him and given the blow.
Yes.
And in eye. And that injury is found in his eye, and PW4 says that.
Lordships may see the circumstances arising in this part, Your Lordships. On that relevant day, he was going to give statement against the same appellant. And as to that part, he has attacked him, and to the doctor himself, Your Lordship, in the cross-examination, it was suggested whether all injuries are possible by fall from cycle or not. The doctor has examined the same, has accepted the same, that the injuries are possible by fall from cycle.
Simply injuries are possible by
no independent corroboration, Your Lordships. As to the witness of PW, the injury is concerned, admittedly, yes, said. And the corroborative evidences, Your Lordship. The younger brother is the post-occurrence witness, and the father was being called by someone that his son is being assaulted. neither the one who said to the father that someone is assaulting your son, neither he has been examined nor the father has stated.
They would have been examined, it would have been more stronger case.
Admittedly.
But it is a case now against you.
Admittedly.
Why should I doubt PW7 and 4? You tell me. PW7 is the injured. He says that you have assaulted him. Doctor finds the injuries. That's enough. Other attending circumstances maybe there may not be there. But 323, what else you need? What else you need?
10 days. 10 days. Okay.
This could have been done, that could have been done, lot of things could have been done. But is it necessary? If there are two witnesses sufficient to prove their case, they stop. They need not examine. See, the quantity of evidence is not important. The quality is important. Quality is PW7 and 4. And the attending witnesses are also there. They see PW1. Who is PW1?
PW1.
Hostile. PW2 is also hostile.
PW3 also.
Doctor.
PW3 supports. Just see corroboration. Para 2, PW3.
It is not a fact that I have stated before police about the.
He was declared hostile. PW5.
PW5 is the informant, father.
He says accused detained my son and assaulted, causing bleeding. All over body, including the eyes, back, and head. My son is not able to see. I took car and shifted to hospital. PW5 also supports.
There are no injuries on the head and back.
PW7. PW7 also.
PW7, your lordship, sir. He's the
No,
doctor, sir.
PW is PW.
7 is the injured.
6.
6 is the younger brother, your lordship.
Yes.
The
Then
post-op.
PW5, 6, 7, and 4.
Admittedly.
Consistent.
4, 6, 7 have been brought in.
Nothing can be done. Undergone period?
9 days, your lordship.
10 days. 10 days.
10 days. 10 days.
10 days.
What is the sentence?
10 days.
Sentence?
6 months.
6 months.
1,000.
Fine?
1,000.
No fine.
1,000.
1,000.
What is the age of this?
Even at the time of 2007, 18, 49 years.
What do you say?
Find out.
Everything is there against him.
Increase the fine.
Yes, sir.
Increase the
Find and the increase, right?
Find.
I'll just grant PO and increase the
Increase the fine.
Find.
Contact what's your name? What is this contact list?
the evidence of the. Okay, that's nice. No, not good.
Item 60 record. 60.
जो पार्ट है रहेगी थिला से
कोड़ा
item 60 है
60
1 year conviction law section 325 5,000 fine
Here is the case, my lord, on the day of Deepavali, while the injured, my lord, crackers, my lord, bursting crackers. At that time, my lord, there is a dispute between the parties, and the allegation is that the appellant, my lord, assaulted by means of a stick, my lord, to the, my lord, injured. Two simple injuries, one is grievous, my lord, that is, my lord, fracture. Widowed 5 is the doctor.
Now, why was it urgent?
Because your lordship, the appellant who wants to contest in the election, that's why my lordship
Trying to,
trying to.
I was not agreeing for acquittal.
Yes, lordship.
Evidences are
1 and
That's
5
it.
is the clear cut evidence for the 25. Even on the same day surrender and same day bail.
no, as per the, my lord, preferred for anticipatory bail. First up, second up, surrender kala.
Bail.
3 SC, since initially, my lord, 3 SC/ST is there.
Acquittal may not be possible. If suppose I'll give you probation, will it affect you in the election?
Section 3, my lord, I verified.
Hmm.
Section 3, my lord, it will help.
Have you got some judgment?
Judgments, my lord, I am gone through the, my lord, one, my lord, 22 gazette notification published by the state of Orissa. In that was included, my lord, at the time of nomination, if any criminal case or conviction, my lord, given particulars to the, in the nomination.
Now, suppose probation is granted, whether you get benefit of that representation of people said.
My lord, that, my lord, only, my lord, I go through the, my lord, that gazette notification published in the year of 2022. That has been amended, my lord, GP Act.
There you have to give a declaration, conviction is there.
Yes.
But if probation is granted to you,
My lord, may I pray, my lord, it will come on Thursday, my lord, I will verify all
you
the.
verify the judgment.
My lord, my lord.
Otherwise,
My lord.
his career will be spoiled unnecessarily for small case.
It's a very, my lord, my submissions before your lordships, my lord,
But
the
I
weapon of
have to
offense.
justify merely in sympathetic ground, I can't do it. I have to justify the evidences that tell
My
them
lord,
what to
Yes,
do.
sir.
That's the reason I urge it.
My lord.
You find out the way, then I can just try to help it out. Because
Thursday
probation is granted, yes.
or next Tuesday, my lord, it will be
next
better.
Tuesday. How recorded? Okay. Anybody is small matter ready? Yes, anybody? What do you want?
The punishment for 3 months and fine of rupees 500 rupees. 39.
Offense?
Offense under section, your lordship, 148, 149.
One?
148, 149, 324, 332, and 452 IPC.
How many of you were there?
There are 5 or 6 appeals.
67 years, 49
Hmm?
years, 67, 62, 55, 59, 60, 50 years. About 60 years old.
Conviction under what provision is it? Who is visible also? Just see conviction under
3 months. 3 months.
3 months, 500 rupees. Each, huh?
148, 452, 332, 324, 149. हाँ 5 दिन 5 days in custody was. Your lordship, appellant number 13426 were arrested on 27th of May 1999 and court forward same day. And appellant number 2
was arrested on 26th of May 1999 and they were released on 31st of May.
All are released on 31st.
If you agree for PO, I will do it. Otherwise, if you are aiming at acquittal, then I have to read it.
You will take instruction from a senior.
You see, otherwise, because see, many accused persons are there.
Yes,
Oh, yes.
Short sentence is there. PO is there. If you agree for PO, I'll. Grant you.
Video has
Huh?
video is the informant.
Is the
Video
writing-
call that.
Thursday, you tell me.
Yes,
Provision of matters. Okay.
I'll take instruction from you.
Tell me your answer. Yes.
Hello, I may be permitted to fetch the song.
You take, no permission is required. You can take it. Okay. You send the files.
Obliged.